Good morning. I'd like to welcome you all to our conference today on patent sovereignty and international law here at the University of California, Irvine School of Law. We're delighted that you all could make it, and I know we have some viewers over the internet, and we're glad that you could connect with us to be part of the proceedings as well. I'll start with just a couple of housekeeping announcements for those who are physically here and a couple for those who are viewing remotely. For those who are curious as to where the restrooms may be, if you go out the doors at the front of this room and to your right down the hallway, you'll find them. We are webcasting these proceedings. So be aware that your image might be caught on the internet, probably mostly the back of your head, but it's possible as you're moving around the room that you might be on video. And perhaps more importantly, be aware that although I'm sure none of you will be holding sidebar conversations during the presentations, since that would be rude. If you do say things, there are microphones around the room. What you say might be picked up on one of the microphones and transmitted around the world, so be aware of that when you're conversing. We'll have 3 breaks during the day, one mid-morning, a break for lunch, and then a mid-afternoon break. We will be muting the audio during those breaks, so it is safe for those in the room to have those conversations and not have the conversation picked up to be transmitted. But for those who are watching the webcast, be aware that at those times you'll see a screen that will have no sound. There's nothing wrong with your instrument, as they used to say on The Outer Limits. It's just that we're not giving you audio at that particular moment. And of course, a reminder to all of those who are in the room that you should please check your cell phones to make certain that they're on silent for the duration of the proceedings. I teach patent law and other intellectual property courses here at the University of California, Irvine. I'm a founding member of the faculty. This is quite a young faculty. We've now been in operation for 7 years and are getting ready to, at the end of this academic year, graduate our 5th class of students. I was very impressed when I joined the faculty that the planning and the preparation for this particular law school has been going on in Southern California for probably a good 25 or 30 years prior to the approval to launch a new law school here at UCI. And the thing that impressed me when I first began to talk to Dean Chemerinsky about joining the faculty was that from the very earliest discussions about this law school, it was contemplated that intellectual property would be a core part of the curriculum and a core part of the scholarly agenda. That, of course, makes a lot of sense to us now in 2015. It's obvious, perhaps, that a major law school should have intellectual property be an important part of the curriculum. But 25 or 30 years ago, that was not so obvious, and that was actually quite visionary on the part of those who did the planning. So there's some colorful brochures floating around and information on the website where you can see how we've tried to realize that particular vision of making intellectual property a core part of the UCI Law School. But part of that is proceedings and conferences like the one that we are presenting to you today. Certainly the topic is extremely timely. The news reports and newspapers in the United States and many other parts of the world for the past couple of weeks have been full of news about the conclusion of negotiations for the Trans-Pacific Partnership, multilateral treaty ostensibly on trade, but that also includes quite a lot of provisions on intellectual property. Those negotiations were controversial. They were conducted primarily in secret without the observation and input from non-governmental organizations and civil society. But within the past few days, we've now seen on the WikiLeaks website the final draft, the final concluded text of the intellectual property provisions. And we'll be hearing about that today, a little bit later on in the program. We'll also be hearing about a number of other international treaties having to do with intellectual property, the Biodiversity Convention, the Nagoya Protocol, and most importantly, throughout the day, we'll be talking about TRIPS, about the Treaty on Trade-Related Aspects of Intellectual Property. And the question that we posed to our speakers for the proceedings today was, in the face of all of these globalized conventions and treaties, what is the role of national law, particularly in the patent area? Is it now the case that one size has to fit all? Or given the differing economic requirements of least developed, developing, developed, and dare I say overdeveloped countries, is there room for flexibility? Is there room for local adaptation and innovation to try and meet the needs of different nations around the world? In order to answer that question, we turned first to the recent Declaration on Patent Sovereignty that is a statement of a group of international legal experts on the question of patents and international treaties, particularly TRIPS, that was promulgated under the auspices and under the guidance of the Max Planck Institute for Innovation and Competition Law in Germany. And we asked our speakers to look at that document and begin with that document to comment, to amplify, to expound, criticize, or take that as a beginning place to think about this question of flexibility and of patent sovereignty in the current environment. Our first speaker today to introduce that document to us and introduce the theme of the conference is Dr. Reto Hilty, who is a director of the Max Planck Institute for Innovation and Competition Law in Munich. I should say that he is also the only speaker today who is a signatory to that particular document. Part of our goal here was to bring fresh voices and fresh perspectives into the discussion about patent sovereignty and about flexibility. But we thought that we should start with a familiar voice who was one of the principal architects of that document and shepherded it through the process of drafting and completion. So he will begin by introducing us to the document and to its goals and to its trajectory. He'll then be followed by Professor Rochelle Dreyfus from New York University Law School, also a very prominent scholar and active participant in the international intellectual property law community. Each of our speakers will speak for about 20 minutes. I'll be keeping time. And then after the two presentations on this panel, we should have at least 30 minutes or so for comments and discussion from the other speakers, from the members of the audience, and hopefully some interaction between the speakers themselves. So I will turn the lectern over to Dr. Hilty to start us off.
How do we manage the presentation? You better. Okay, which one is that? The first one. No? Sorry. Yeah, do it again.
Sorry.
Yes. Yes, this one.
Okay.
Excellent. Okay. Great. Well, good morning, everybody. I'm really grateful to Dan Berg for organizing this event, giving us the chance to discuss the patent declaration with eminent patent lawyers from the United States. As far as I understand, this is the first event dealing with this patent declaration. What I would like to do in this short introduction are basically 5 things. First of all, I would like to explain a little bit the background and the purpose or the purposes of the declaration. Then I would like to reason on some facts and figures. I would, of course, also try to highlight some key issues regarding the regulatory autonomy or regulatory sovereignty, as we call it in this declaration. Sovereignty according to the declaration, you may be of other opinion. Then I would like to say a few words on our agenda for the dissemination of this declaration. And finally, if time permits, I would like to give you an idea on some possible follow-on projects. To my own regret, I'm the only representative, Dan has mentioned it already. You see the name of Matthias Lamping on the slide as well. It was scheduled that he would be here as well, but he cannot be here for personal family reasons. And I really regret it because he was extremely important for the whole declaration, in particular for the drafting process of this declaration. So, first of all, background and purposes. Viewed historically, the patent declaration does not, ironically, not root in patent law, but rather in copyright law, in concerns about copyright law, because 10 years ago, the Max Planck Institute, we started a project primarily focusing on the interpretation of the three-step test in copyright law. That was a cooperation between the Max Planck Institute and Queen Mary, and the aim from the very beginning on was to draft a declaration. Some colleagues, however, argued that an isolated copyright declaration was the wrong approach. Problems in patent law would not be less severe, but even broader and wider. Therefore, a general declaration would be appropriate, covering both copyright law and patent law, or possibly even go beyond. Rochelle was one of those voices. We nevertheless completed the copyright declaration first in 2008, primarily because we were of the opinion, and meanwhile the wide perception of the copyright declaration confirms that the communities we want to address are not the same. At the same time, I agreed that we would, after completion of the copyright declaration, get to work on a patent declaration. This patent declaration was completed last year, and it was launched at the 20th anniversary of TRIPS, so on 15th of April 2014. It is not difficult to see that the two declarations are closely related, not only because the statements on the three-step test are quite similar, but also the approaches of the two declarations are comparable. Most importantly, both declarations accept the international law as it is, in particular the TRIPS agreement. We are aware of other projects, and of course we are also involved in other projects which base on the opinion that TRIPS should be changed or try to challenge certain provisions in TRIPS. We do not believe that this is a very promising way, at least not on short notice. For this reason, we think it's more appropriate to reinterpret TRIPS in a way that it can be accepted as it is. One may, of course, scrutinize the idea of drafting such declarations at all. The reasons why we believed that this approach may help under certain conditions are the following. Academics sometimes have, I think always have important things to say, but they are not always heard in, let me say, real life. Consequently, their findings have little impact, which is particularly true in policy-making processes, respectively law-making processes. This is not really surprising if you give account to the fact that we primarily publish within our own communities for academic purposes only. Living in our ivory towers, we produce long papers or even books written in technical language. This is, of course, necessary as well, but if we want to be heard, we need to learn from professional lobbyists. We need to express our thoughts in short, concise, and understandable ways. In fact, if you have a look at the declaration, you see that the declaration as such, so to speak, the part containing provisions, comprises of about 5 pages. The preface explaining the purpose of the declaration is less than 2 pages, and the considerations that you do not necessarily need to read, but they explain the purpose of the declaration or the background of the declaration comprise of less than 10 pages. As to the substance, the patent declaration bases on the assumption that numerous TRIPS provisions to a large extent are misinterpreted. In particular, developing countries or threshold countries or NGOs defending their interests tend to blame TRIPS to be too IP-friendly and in particular too patent-friendly. This, however, inures the comparatively large leeway, we call it regulatory sovereignty, that TRIPS leaves to national legislatures. On the other hand, this sovereignty is endangered in some countries. The danger roots in the attempts or in certain attempts from other countries to put pressure on, in particular, developing or threshold countries to go beyond the minimal protection requirement imposed by TRIPS or by other international treaties. This strategy usually is based on free trade agreements, bilateral or regional free trade agreements, containing obligations to amend domestic IP systems, and quite often countries concerned assume such pressure based on trade-offs. Also, they do not necessarily benefit from higher standards of IP protection with a view to the domestic socio-economic framework conditions. They want to benefit from certain trade privileges related to domestic goods. In view of this danger, the Max Planck Institute has initiated a further project resulting in what we call principles for IP provisions in bilateral and regional agreements. These principles have the purpose of warning states concerned to actually preserve their regulatory sovereignty, whereas the declaration that we discussed today has the purpose of highlighting and explaining the scope of this regulatory sovereignty. Having said this, it is even more important to emphasize what the declaration does not intend to do. It is not the purpose of the declaration to tell the countries, any countries, industrialized or not, what they ought to do. It is also not the purpose of the declaration to deny the value of IP protection in general and patent protection in particular. Rather, the declaration leaves it open to what extent patent protection may have positive impacts. It emphasizes, however, that it is likely that not all countries in the world currently are in the position of benefiting from the same degree or the same approaches of protection than has already mentioned it in the introduction. And it's also not the purpose of the declaration to blame Western countries or even damage Western industries. In other words, the spirit behind the declaration is neither patent hostile nor patent glorifying. It is open-minded with a view to the upsides, but also to downsides of the patent system, well understood from a global perspective. The declaration has not been written in order to serve emerging countries only. Certain downsides of the patent system particularly affect the industrialized world. We will return to that in a few minutes. Admittedly, insufficient IP protection may lead to market failures. A lack of legal certainty may disincentivize investments, but also inappropriate protection, you may call it overprotection, is likely to impede the functional capacity of a market. Just think of the Patentdickicht discussion increasingly becoming a concern, particularly in the IT industries, but also beyond. But also think of strategic patenting or strategic behavior of patent holders, possibly non-working patent holders. They also may have impacts in various forms, or think of inappropriate enforcement of patents, in particular standard essential patents, which risk producing dysfunctional effects, etc., etc. If you read the preface, you find further much more convincing examples in section 3 of the preface of the declaration. Again, the declaration does not show concrete ways how to deal with such challenges, but it highlights the leeway the member states actually have to address the given challenges. Some facts and figures may help to understand why concerns about the patent system generally are justified and not only an issue of emerging economies. Take only the breathtaking increase of patent applications, for instance. You see it in colors. Red color is China, blue color is the United States. It raises this breathtaking increase of patent application, raise a number of questions, for instance, whether there is indeed a correlation, a direct proportional correlation between the number of patents and innovation. Even if not all or even a minority of all applications ultimately lead to granted patents, we currently are faced with roughly 10 million patents in force worldwide. This may not sound like a problem per se. However, if we are aware of the number of patents in one single smartphone, certain questions suggest themselves. One of these questions concerns the impact of this enormous number of protected technologies for other market participants, and in particular for newcomers on those markets. Based on the huge number of patents in these particular industries, economists have calculated the theoretical, of course, monitoring costs per year, well understood for the US software market only. You may or may not believe this value. In any case, it suggests a disproportionality of such costs. For instance, if we compare these costs to the total revenue of the US software industries in 2014, these revenues amount to 13% only of the admittedly theoretical monitoring costs. But not only IT industries are concerned, other economists have calculated the annual wealth loss in the United States due to litigation of non-practicing entities. This amount, 13 billion US dollars, corresponds to more than 20% of the yearly research and development expenditure in the United States. The United States in particular, the United States in particular have further reasons for concern, namely related to the pharmaceutical industries. Patents, in combination with an unregulated market for drugs in the United States, help to increase the prices for drugs dramatically. In 2014, compared to the previous year period, the increase amounted to 11.5%. At the same time, the GDP grew 2.4% in the United States only. During the same period, the price increase of drugs in Europe was limited to 2.4%, not 11.5%. And of course, Europe is a highly regulated market. In the rest of the world, the price increase was 4.9%, but not 11.5%. Not surprisingly, the US market contributes almost 50%, 47 exactly, to the global sale of drugs obtainable only on prescription. In other words, prices for drugs are not only an issue for countries like India, it's also an issue for the United States. Well, what are the key issues as to the regulatory sovereignty according to the declaration? I want to be relatively short. You know the declaration, or you can read it. It's distributed everywhere. You can read it yourself more carefully. Most importantly, I should emphasize first that all participants that you can find on page 19, these are 39 people, agreed on a final document, on this final document as a compromise, not necessarily on every single provision or consideration. Rather, the vast majority recognized the value of the declaration as such, even if there were varying minorities with regard to certain statements. In other words, the process that we had then was present, Rochelle was present as well, was a highly democratic procedure. But at the same time, we agreed that this reached compromise should be subject to further discussions, possibly also to dissenting opinions. For instance, contributors or those who signed the declaration may write their own papers with own opinions. For this reason, you also find at the very end of the document an indication version 1.0, which means that we might come to a version 1.1 or 1.2 or even a version 2.0 and so on. In the substance, Article 27 of TRIPS obviously is kind of an anchor norm for the whole declaration. It has an impact in several regards. First of all, regarding the question whether, from a technical perspective, one size fits all. We are obviously not of that opinion, for which reason the declaration states in section 2 that Article 27 does not prevent states from reasonably differentiating according to the characteristics inherent in the technology or states' public policies. The same norm has an impact on the question of patentability. According to the declaration, section 3.1, Article 27 does not require states to provide patent protection for subject matters that they classify as discovery rather than inventions, but of course they may go beyond, like the United States, also protecting discoveries, or subject matter that they do not consider to be technical in nature. Further, in section 3.2, the declaration states that Article 27 does not prevent states from denying patent protection for new uses of known products or substances, for derivative or known products or substances, or for selection innovation. As to Article 29 of TRIPS, the disclosure requirement, but still about patentability, the declaration states in section 3.3 that states are not required to provide patent protection for innovations that have not been sufficiently disclosed or expressly claimed in the patent application. This sounds obvious and clear, but if you read the considerations in section 12, you see that there are borderline cases. Just think, for instance, of the software code, source code of software. Back to Article 27, but now related to the scope of protection. The declaration states in section 4 that Article 27 and 28 do not prevent states from limiting the protection conferred by a patent to products or processes in relation only to the specific function or functions of the invention expressly claimed in the patent. This is, of course, highly controversial, and I'm aware that we certainly will discuss this also today. Further, regarding compulsory licensing, the declaration in section 7.1 is remarkably open by stating that Article 31 of TRIPS does not limit the grounds on which a compulsory license may be granted, and even more extensive in section 7.2 that the non-discrimination principle in Article 27 does not apply to compulsory licenses otherwise permissible. Finally, the working requirement is addressed in section 7.3, but this is a topic per se. Marketa Trimble will talk about that, so I don't want to go into further details. A last remark on enforcement, Article 44, which might be less controversial, at least in the United States. Section 10.3 of the declaration says that states are not prevented from denying injunctive relief to prevent or control abuses or other inappropriate conducts by the patent holders. What are we going to do with that? We have an agenda. As I mentioned, the declaration was launched last year. Meanwhile, we have prepared kind of a world tour. At least part of this tour is mirrored here on the slide. We might also go to other places. The idea behind this tour is that we will apply very similar agendas of these events in all the different countries, with the idea that we have comparable workshops and we have comparable outcomes from the different places with different perspectives. You see that we also have the event today, but I have it in brackets because we have a slightly different agenda compared to the other ones. Most importantly, we want to reach and we want to hear domestic experts in particular officials, but also the industries from the countries involved and other stakeholders, and of course also the local academics. Based on that, I mentioned it already, we hope to be able to prepare a version 1.1 with corresponding explanations, or even a version 2.0 if the critique should be too fundamental and if we should amend more than just certain statements. This has not yet been the case, but the first event we had was in China, and China obviously was in favor of this declaration as it is. Maybe a few words on possible follow-on projects. Of course, a number of possible follow-on approaches exist. At this stage, I just would like to show one project that we have in mind based on a few slides. This is an empirical study on what we call third-party entitlement to use patents based on different legal foundations or legal bases. The slides is a little bit complicated. I think it doesn't make sense that we explain it in detail. It's just there to clarify that the legal situation is quite multifaceted in different countries and very much depends on the legal tradition of the countries concerned. We have started kind of a test run in 15 Asian countries, but we would like to extend the research to most important countries worldwide. The study bases on a detailed questionnaire which is distributed to, let me say, persons of confidence. These are people that we know in these countries and people that we have been working together with. Nevertheless, the whole project is highly complex and it is very time-consuming. A very preliminary finding on the implementation of the flexibilities permitted by TRIPS concern, for instance, statutory licenses. Statutory licenses are uses directly permitted by legislation. You can also call them exceptions. Or compulsory licenses, which are uses permitted by court order or administrative decisions. Of course, we do not want to know the theoretically existing situation in the countries only, but we would in particular like to find out more about the impact of these provisions in practice. For instance, whether or not compulsory licenses have been granted at all and under what conditions. This is one of the slides that may explain that. As mentioned, we intend to extend this study to a number of other countries, but don't expect results too promptly. This is highly time-consuming and it's not easy. It's kind of a back and forward discussion with these experts. Useless to say that we would, of course, want you to support the declaration. I'm aware that you may not agree with everything which is in the declaration, but think about the spirit behind the declaration. And if you support the declaration, in principle, please sign. You do not need to write as a paper, just write. It took me a long time to do that. Just write as an email on this email address and contribute to the further discussion that will help all of us. Thank you very much.
Oh, you're here, good.
What's the title of your talk?
RCD now.
Oh.
I don't actually have very many slides, but this is going to work? Yeah.
Yes.
Okay.
And Rochelle,
Yeah.
if you want to.
Oh, yeah, right, thanks. Oh, God. Probably splendid, yeah. All right, well, thank you, Dan, for organizing this and offering me all kinds of aids for my bad back. And thank you especially to Rado and the Max Planck Institute for all the work in developing this declaration. It's a tremendously important contribution to IP. And as you heard, I'm especially glad to see it because I've been hounding Rado to do something on this since 2006 when the Copyright Declaration issued. Because I really thought that the exceptions for both copyright and patent were equally mangled by the WTO dispute resolution panels, and I was eager to see an equivalent critique for patents. And the new declaration provides a wonderfully detailed discussion, so thank you. And as we heard, the declaration also goes very far beyond the three-step test to address TRIPS patent provisions more generally. And that, too, ought to be a very welcome development. And I think so for three interrelated reasons. First, the declaration could serve an important authoritative interpretive role. The WTO took over international IP lawmaking because the trade hands running the GATT saw intellectual property rights as commodities equivalent to steel or sheep. Looked at that way, they failed to perceive the important differences, especially as they relate to health, culture, and innovation. Further, they thought a mere right to exclude posed no threat to sovereignty, and so they didn't include an analog to the general exceptions provisions that exist in the GATT and the GATS. The absence of such a measure puts a great deal of pressure on how individual terms of TRIPS are construed. Unfortunately, however, those who decide WTO cases are no more knowledgeable about IP than the drafters. They, too, are mostly trade hands. Even when drawn from IP practice, they never sit in the area of IP that's actually presented by the case that they're sitting on. The WTO could therefore use an authoritative interpretation of the agreement, the considered judgment of neutral specialists and scholars assembled from all around the world that would ground adjudicators and future negotiators in the policies and values that undergird IP. Such a document would help illuminate the object and purposes of the TRIPS agreement, shed light on the scope of the rights protected, and provide a rich basis for implementing the three-part exceptions test. An authoritative interpretation would be even more important to other fora. After all, the WTO actually doesn't have a monopoly on deciding the compatibility of local law with TRIPS. Those issues will come up in state-to-state dispute resolution under the TPP, and more important, they advise an investor-state dispute settlement, ISDS, under NAFTA, the TPP, and various bilateral investment treaties. For those of us who seek a balanced approach to IP, who think of IP as an incentive to invent, not a commodity of trade or an investment asset, ISDS poses a substantial threat. Most obviously because in these instruments, TRIPS compliance is a defense to a claim of indirect appropriation, so the state whose law is challenged must prove compatibility. In the WTO, the burden of proof is on the complainant to show noncompliance. In cases where evidence is scarce, a state that would win in the WTO could easily lose in ISDS. Furthermore, as Jus Powellen documented, those who sit on ISDS panels differ in significant ways from those appointed to resolve disputes among states. Their priors on property, on sovereignty, are shaped by very different backgrounds, most especially because they are all commercial arbitrators, not state-to-state arbitrators. Or as Jus colorfully puts it, WTO panelists are from Mars, ISDS arbitrators are from Venus. A carefully reasoned construction of the text these Venusian panelists will be asked to interpret, emanating from a distinguished source like the Max Planck Institute, would be an extraordinarily useful resource. Authoritative interpretation is also important for member states for reasons that Rado mentioned. They need to know what flexibilities are available to them, both for domestic lawmaking and for future negotiations. Closely related to interpretation is guidance. IP is, after all, intended to strike a delicate balance between the interests of innovators and the public. Doing that right in light of each country's domestic conditions can be difficult, even harder than merely identifying flexibilities. Those new to IP could use advice from senior people in the relevant fields. Third, the declaration could help establish norms. As Graham Didwoody and I argued in our book on a Federalist Vision of TRIPS, Because there's no ius cogens of intellectual property law, there are no hard norms that arbitrators, negotiators, etc. feel they cannot cross. So the North accuses the South of stealing their IP and free riding on their ingenuity. There are no equally catchy phrases on the other side to counteract that rhetoric. The Max Planck Declaration could supply the principles required. So what I'd hoped for was authoritative interpretation, guidance, and norm building. I realize it's a tall order, and much of that was accomplished. But in the rest of my remarks, I'll provide what I hope are some constructive suggestions for version 1.2 or 2.0, whatever you want to call it. So I'll start with the interpretative function. To be authoritative, the declaration has to be impeccable, beyond reproach. It won't be a help to states that must justify their actions if those sitting in judgment can see places where the document is nothing but pure advocacy. Advocacy is, of course, not a terrible thing. Advocates are essential when a country is embroiled in a dispute. But the work of advocates is thick on the ground. It's available from the Third World Network, KEI, Doctors Without Borders, UNCTAD, the World Health Organization, and many other places. I had hoped for something different from the declaration, but I don't think it's what we've got. So what do I mean? In my paper, I talk about a few representations that to me are at the edge of implausible. Here I'll talk about just one, but it's enough. You only need one glaring piece of advocacy to destroy the integrity of the declaration as a whole as an authoritative interpretation. So that one is Section 4, entitled Scope of Protection, which says that Articles 27 and 28 of the TRIPS Agreement do not prevent states from limiting the protection conferred by a patent to products in relation to the specific function of the invention expressly claimed in the patent. Now, Article 27 of TRIPS says that patents shall be available for both products and processes. And Article 28 carefully delineates the rights attached to a product patent and the rights attached to a process patent, and they are supposed to be different. But what is a product patent that is limited to its specific function? It is essentially a process patent. How do I know that? Well, consider how a product patent is enforced. The patent owner sues the accused infringer. In the usual case, the infringer might defend by saying, I'm not using the claimed products, or he might say the patent is invalid. But if the patent is limited to a specific function, then the infringer can also defend on the ground that he's not using the product to perform the claimed function. And then the patent holder will have the burden of showing that the infringer is using the product that way. And that's precisely what the holder of a process patent has to prove, that the accused infringer is accomplishing a particular function using the patented invention. As holders of process patents know, sustaining that burden can be difficult. Products can have more than one function. For example, bioactive molecules can turn out to be effective as treatments for more than one disease. In such mixed-use cases, monitoring infringement can be difficult because those using the invention will claim that they're using it for the functions not recited in the patent. And when there's litigation, the party with the burden of proof, the patent holder, will often lose. Many countries lack the kind of discovery needed to permit patent holders to show exactly what it is that a defendant is doing with a product. And some countries may even have privacy laws that shield that kind of inquiry. That is why there is virtually no debate whatsoever among economists or patent lawyers that process patents are much less valuable than product patents and offer fewer incentives to innovate. The flimsiness of these patents is presumably why advocates for minimalist protection prefer a rule that turns product patents into process patents, and it's also why we can be quite sure that TRIPS negotiators did not create such a rule. Aside from the impact on incentives, think about the temporal effect of that rule. To avoid the mixed-use problem, inventors such as pharmaceutical companies will likely delay patenting and marketing until they think they've found all of the product's significant functions. That delay won't be limited to countries that adopt this rule because the global patent system is intertwined through the Paris Convention's priority rules. Wouldn't the negotiators of TRIPS have at least debated the social cost of delay before drafting a provision that allows one country to unilaterally inflict that result on the entire WTO? Now, the drafters of the declaration claim that the existence of limited patents for genetic inventions in some European countries proves that such a rule is TRIPS compatible. I think it doesn't do it at all. First, the EU rules haven't been challenged, so we don't know what adjudicators will think. But more important, genes are a special case. The U.S. invalidated patents drawn to genomic DNA a couple of years ago, and a couple of weeks ago, Australia invalidated all gene patents. Both considered them natural phenomena. The Australian High Court also made a point of noting that these patents would have a negative effect on innovation, a chilling effect on activities beyond those formerly the subject of the patent, and that they conflict in important ways with both public and private interests. In such circumstances, TRIPS would permit countries to exclude the subject matter from protection. Well, if total exclusion is permitted, then the EU rule, which stops short of exclusion and instead limits the scopes of these patents, is probably also permissible. That's not free of doubt, but it's likely. Anyway, the point is this. The limitation for genes, even if clearly valid under TRIPS, does not support the notion that every product patent can be limited to the recited function. I think any decision maker, any lawmaker who looks at that provision will immediately consider the declaration advocacy rather than neutral, authoritative scholarship, the thing that we would truly value having. So much for interpretation. How about guidance? Here, too, I think the declaration could do much better. It assumes that patent sovereignty means national power to offer the minimal protection. But is that the power that countries actually want? To be sure, some developing countries are very far behind and do want to maximize access. But TRIPS is largely irrelevant to them because the transition periods keep getting extended. For emerging countries, things are very different. They know they're operating in a knowledge economy and that they will prosper only if they become innovative as well. Furthermore, empiricists who study emerging economies are finding that innovation in these places is increasing, in some cases quite dramatically. Many of these countries can reasonably aspire to become technology leaders rather than followers. Well, does the declaration provide countries with these aspirations with the right kind of guidance? Consider Section 4, the section I just spoke about, in conjunction with Section 3.2, which provides Article 27 of the TRIPS Agreement does not prevent states from denying patent protection for new uses of known products or substances otherwise lacking novelty or inventive step. Depending on how novelty and inventive step are defined, the joint effect could be to strip a system of all incentives to find new functionalities. That is, when a product patent covers all uses, it protects the new ones as well as the old ones, the recited ones. But if the patent covers only the recited use, that's no longer true. Now, countries can generate an incentive by offering new patents for new uses. The prospect of such a patent will equally encourage exploration. But if you remove that reward too, then there is no way to appropriate a return from this sort of investment. And yet this is exactly the kind of research emerging economies are best positioned to do. They're uniquely aware of the special needs of local communities, things like finding drug formulations that don't require refrigeration. For the South, costs may be lower and the ability to experiment more convenient. Besides, countries not in a position to make large technological leaps may be very attractive to working on incremental advances. The declaration would be more useful if it set out the implications of implementing both Section 3.2 and Section 4. Even better if it provided developing countries suggestions on how to choose between them. More generally, it would be wonderful if version 2.0 provided an even-handed discussion of the pros and cons of using the flexibilities identified and said something about how to mix and match. Well, how about norm building? Here there are many things to like about the declaration. The first part sets out basic principles that are obscured in the TRIPS agreement as well as in subsequent bilateral and plurilateral instruments. For example, in the ISDS case that Eli Lilly brought against Canada, one of the claims is that post-NAFTA, Canada can't change its utility requirement even in a TRIPS-compatible way because change would undermine Lilly's expectations and amount to an indirect expropriation. The Declaration begins with a wonderful description of how the patent landscape necessarily changes over time and makes crystal clear that norms derived from real property or tangible property can't be mechanically applied to a system of law intentionally designed to encourage disruptive innovation. The early section also elaborates on the significance of competition, the importance of a robust public domain, the necessity for industrial differentiation. It sets out core exceptions for experimental use, education, marketing approval, and much more. Now, I've argued that these principles would be better protected by agreements that recognize user rights. And interestingly, there are hints of that approach in the copyright section of the TPP, and not surprisingly, you see it in the UN Special Rapporteur's report on patents. But for various political economy reasons, we are unlikely to ever see a full-blown multilateral user rights agreement. Accordingly, the Declaration's discussion of these matters is a profoundly important contribution to norm development. To my mind, however, the Declaration's obsessive concern for maximizing flexibilities detracts here too. It looks as though the goal is to help countries take that free ride the North is so worried about. The more it pushes the envelope, the more strident will be the North's demand to ratchet up the level of protection. And the clearer it makes these flexibilities, the clearer it becomes how to shore things up. So, for example, what do we see in the TPP? An explicit requirement on second-use patents. Well, what would be better? One issue I've been playing around with is exhaustion. So in Section 5.1, the Declaration provides that Article 6 of the TRIPS Agreement does not prevent states from determining whether patent rights are to be exhausted nationally, regionally, or internationally. Now, that's certainly a true statement, and it appears in the TPP as well, but I actually wonder if it's the right rule. There are two problems here. First, exhaustion has enormous spillover consequences. The choice any one sovereign makes to favor access interests can spread to every country that adopts a rule of international exhaustion. Second, by washing its hands of exhaustion, TRIPS leaves countries with no control of the position their trading partners take. A country can't say our economic problems are such that we need to enact a rule favoring consumers, but that rule is only for us. It can't do that. It can't limit the rule to its own territory because other countries are free to recognize international exhaustion and define it to include all sorts of ways that goods can become available lawfully. To protect their home markets, then, the North has little choice but to try to impose stringent substantive law on foreign markets. Version 2.0 could make clear exactly what exhaustion means, that a country can regard a right as exhausted only if the goods were placed on the market under the voluntary authority of the patent holder, that a purchase of goods unpatented in the country of first sale does not trigger exhaustion, that sales under a compulsory license do not trigger exhaustion, and indeed that the sale of goods sold under the threat of a compulsory license don't trigger exhaustion. That would go a long way to assuaging some of the concerns that lead the North to pressure the South to adopt law inappropriate to their circumstance. I have one more suggestion. I know it's not what the current declaration aims to do, but I look forward to a project offering a more normative approach to international lawmaking generally. Instead of asking how to maximize patent sovereignty by exploiting ambiguities that happen to exist in the current draft of the TRIPS agreement, it could suggest how the agreement should be structured to create the appropriate level of sovereign authority. The last section of my paper gestures at such an approach. It was suggested by Esteban Donoso, an Ecuadorian practitioner and ex-student, and has actually drawn some interest from both WIPO and the WTO. So Esteban's view is that every country not in transition is in fact interested in having a patent law that encourages innovation. And each would actually like to destroy the perception that it wants to free ride on the North's inventiveness. But what each would like to pay is a fair share, and only a fair share. An agreement that demands essentially the same from every country requires citizens in the South to pay a much larger percentage of their income to patent holders than citizens of the North. Nibbling around the edges of patentability requirements and pushing the envelopes on defenses to infringement doesn't rectify this problem very much. Better would be to bar countries from recognizing exhaustion, so say what happens in Ecuador would stay in Ecuador, while also changing Article 33 of the TRIPS agreement, which currently requires every country to have at least a 20-year minimum term of protection. Instead, the WTO would calculate the minimum term for each country based on an agreed measure of wealth. Ecuador, for example, might have a 10-year term rather than a 20-year term. That way it would pay around half of what developed countries pay in patent royalty. In other words, its fair share. To be sure, Ecuador and other governments in similar positions would probably wind up having to shoulder the expense of furnishing citizens with necessary patented goods like pharmaceuticals. But since they would need to do it for a shorter term, they might be willing to relinquish the right to, say, issue compulsory licenses, which after all destroy local incentives to produce precisely those inventions their citizens need the most. Further, they might be more receptive to the patent law treaty and full-scale harmonization of patentability requirements because they'd be able to save money on examination. They could rely on foreign examination or participate in cooperative arrangements, and it will allow them to rely on foreign adjudications of invalidity. And indeed, global licensing and enforcement actions would be simpler for everyone. Economists have long argued that patent terms should be individualized by industry. But given the imagination of patent drafters, that idea is not administratively feasible. Interesting, this one actually is. Now, to be clear, I'm not asking Max Planck to adopt this proposal. I'm not even sure I agree with it myself. But it's a good example of the kind of direction that the Declaration hopefully inspired in your next projects. So I give it to you as a constructive suggestion. Thank you.
I want to thank both of our speakers not only for the substance
Do you
of
want
their
us to sit here?
presentations. Yeah, if you
Because I'm
wouldn't-
not going to sit there
if you
and
wouldn't
then
mind.
sit it
Yeah, I
down
think
again. Those of us in pain worry.
The substance was wonderful, and they were also very well disciplined on their time. So we have about 20 to 25 minutes to discuss. First of all, open this up to the audience to see what questions might have been prompted there, and perhaps the speakers also have some back and forth comments to one another. So first of all, questions or comments from the listeners at this point. Reto, did you have any thoughts or responses to some of Rochelle's suggestions, particularly the very, very detailed suggestion on exhaustion?
Very detailed indeed, yes. And not all of them are entirely new because
Esteban has an entire book on this. It's much more detailed than his book with actual amounts and what it would mean in terms of royalty payments and things.
As to more guidance, this is of course true, and this was one of the major critiques that we received regarding the copyright declaration, I must say. I remember I was presenting it once in Geneva in a side event at the WIPO, and their developing countries said, this is a wonderful document, but it doesn't help at all, because we need our states to say what they have to do. They cannot just take the flexibility and then they know how to go, the right way to go. For that reason, we have started or almost completed a follow-on project in the field of copyright law, and I can imagine that we should do that in patent law as well, which is, we call it instrument on permitted uses, which means that we explain that it's also an international group working together. It's not the Max Planck Institute itself, and people from all over the world, where we try to explain which are, so to speak, the minimal rights of users. I know that the term users' rights is a dangerous term. That's the reason why we just call that not users' rights, but permitted uses. And they try to define a minimum which needs to be established in every state. And the purpose behind that instrument is not only to give guidance to those states who would join this instrument, treaty, whatever it would be, but also to kind of bind their power in negotiations on free trade agreements, etc., that they are more powerful, saying that we stand together and this is our red line. We don't go behind this red line. We need this kind of permitted use, etc. And I can imagine that we should do something similar in patent law, but maybe it's a bit too early at this stage because there are many controversial points, and of course Rochelle raised some of them which are really relevant. As to this function bound protection, I must say that I'm a little bit hesitating. I learned the very first semester when I was a law student that we should treat equal things equally and unequal things unequal, because if we treat unequal thing equal, we come to an unequal result. So if we have different impacts of protection in different fields, I think we should pay attention. And an example that I always have in mind that I teach my students is, and you certainly know it much better than I do, is nanotechnology. If in nanotechnology is kind of a mixture between a product and a procedure. You have nanodots, nanotubes, etc. These are, so to speak, the very small, the nano little machines. And if you protect these machines, which can do many other things, have many functions, if you protect this machine as such and you monopolize it, the one who has the patent on this little nano machine can control all applications in the world based on these machines. For which reason, I think this is a good example, for which reason we really have to limit the protection on the function of this machine in specific circumstances. And also in the field of chemical innovations, or in particular pharmaceutical innovations, there is a special situation for which reason we have this second indication, third indication, medical indication, etc. So I have the feeling that we have different cases with different impacts, and we probably have to treat them differently. Which way ever? That's another question, of course.
It's really technology specificity.
Exactly.
Rochelle, would this kind of a statement on principles, first in copyright, but then perhaps in patents, go to the comment on user rights? Yeah.
I think that would be great. I mean, that's exactly what I would like to see, so that would be terrific. On things like nanotechnology, and I've also strongly believed that you can differentiate by field of technology. I've written about that. But I think you do have to explain why. So for things that have tremendously different effects, I mean, I think under current law you might say that that's a phenomena of nature, and you just exclude it entirely. If you want to make an argument that says, well, excluding it entirely is also wrong, therefore we need special rules about it, but that's not what this declaration does. This declaration says you can do it for everything, and that's the problem to me.
So your sense is that there are other policy levers or other areas of the...
Yes, policy.
Yes, right.
Yes, indeed.
But they could accomplish what Greta would like to do, maybe
Right.
not with the...
Right, and as I think as your book with Mark points out, there are other fields too where this might be important. I mean, I think we're having a huge problem with computer technology right now, and there might be better ways to deal with that as well. But by staying within sort of the strict terms of the TRIPS agreement, you never get beyond that to start thinking about these new technologies that the TRIPS people didn't think about any technologies, but they certainly didn't think about these new ones. So I think that's good. What I am puzzled about was the thing at the end. If you're trying to have an authoritative interpretation and people don't agree with you, why sign on? I mean, it just destroys everybody's ability to try to be a neutral expert on these cases by signing on to this if you think that certain things are just clearly not right. So it's just not clear to me why you agree that things might not all be perfect, but you still want people to sign on.
So I guess I have a slightly different question with regard to your authoritativeness and norms creation and interpretation. And I'd be curious to know what you think, and there may be people in the audience who have an idea also. Being based here in the United States, it's very unusual to see a court, or really anyone, talk about TRIPS, right? If you go elsewhere in the world, if you go to the European Union, if you go to other countries. Yeah, they start out by talking about their treaty obligations. As far as I can tell, we don't really care about our treaty obligations. And so I wonder what
Unless it allows Congress to do something that we actually think is a bad idea, right? Then
Well,
suddenly, well, they're following what we have to do.
sometimes when it's convenient, we
Right,
talk
right.
about treaty obligations,
Yeah.
but it's I have never seen a U.S. court start out the way that the Australian court
Yeah.
does, or that the Court of Justice of the European Union does, by talking about the relevant treaty provisions that they're signatory to. So, what impact or what potential does a declaration, either 1.0, 2.0, 1.5, have in a country like the United States, where we still have a lot of work to do to even get them to recognize that there is a treaty such as
Oh, I
TRIPS?
think it does no work in the United States. As I said, I'm particularly worried about ISDS. I mean, these are people who are drawn from commercial arbitration. They are all from developed countries, not undeveloped countries. Many of them have never seen an IP dispute before. These guys are repeat players who make the big bucks by writing decisions that make them repeat players. So, I mean, how would you be a repeat player in ISDS and in intellectual property? By recognizing intellectual property, as an investment asset that can be expropriated. So they start off with a set of priors that are so inimical to all of the values of IP. That's where I think something like this declaration could be incredibly useful. I mean, they're going to need something short. I mean, what Rader said at the beginning about it's short, it's compact, it's easy to understand. They need that. I mean, even if it's not the basis on which they decide, at least it sets them along the right path. And so I would like to see something that really is authoritative, because in one country, Canada shows it to them, and then, Eli Lilly says, but look at this provision, it's clearly wrong, and that's the end of that. So it's not for U.S. courts. U.S. courts are never going to listen to this, but it's for ISDS. It's for WTO panels. The TPP, I think, has state-to-state dispute resolution now, so another place where you're going to see. And it's also, I think, going to provide that if you do something that's TRIPS compatible, then it's a defense. So TRIPS compatibility is going to come up in a lot of different situations. It's not even clear that a WTO decision on a particular issue is going to be considered precedential and binding. And we don't have very many WTO decisions, and I think we'll probably wind up with more ISDS cases than WTO cases, because these investors really don't care about the diplomatic implications of what they're doing. So, where Switzerland decided not to go after India on Article 3D, if there were a investment treaty between Switzerland and India, you can bet that they would be bringing that case. And Europe is going for those kinds of, Europe, the North, I should say, not Europe, are going for those kinds of agreements because they want to be able to allow their investors to bring those cases. So that's what I worry about.
Reto, is there any thought in the agenda going forward to give special attention to outliers like the United States, or to do some consciousness raising?
Well, if you had a look at the agenda, you'll see that we really start. I mean, I was happy to come
China,
here, but this is it's
yeah.
kind of an exception, because of course I tried to discuss with the easy countries first,
and then move to the difficult ones.
The United States can be educated about the kinds of things that the United States thinks are problems. I mean, that's not educating courts, it's educating the USTR. I mean, they could use an education too.
So we've got a couple of questions from the audience. I want to ask the technical staff, will the questions from the audience be picked up, or should we repeat them to make sure that they're... okay, we'll repeat them. So Marketa? Yeah.
So in that case, I'll ask a short question.
Okay.
I think it's tremendously important to have a project that explores all the flexibilities and presents to countries and various parties and stakeholders what might be the outer limits of the flexibilities. But from my experience as a former governmental officer, it's not always lack of expertise or knowledge about these flexibilities and their outer limits that prevents countries from fully exploring and using those flexibilities. Could you talk a little bit about the other barriers to using and exploring all the flexibilities that might be available?
So the question is, Marquetta senses that it's not a lack of knowledge that causes countries to fail to explore flexibilities or local adaptations of the treaties. What are the other barriers and how might they be addressed?
Well, I think the situation in the US and in Europe, and if I say Europe, I mean Brussels, is very similar because there the pressure of the lobbyists is extremely high, and Brussels at least would never listen to an academic. They would never ask you a question. On the other hand, that's what I also wanted to say before, it was a good experience to see the impact of the Copyright Declaration in the Marrakesh Treaty. This was very, very present, and there was even a proposal from certain countries, of course, and you can imagine which countries, that this interpretation of the three-step test should be implemented in the Marrakesh Treaty, that it should be much more open, etc., etc. And you also can guess which countries were against, for instance, the United States, of course, but there was an impact of these papers, so it's not irrelevant. But of course, if you have the pressure groups behind, and in copyright law, it's even easier to understand who is the pressure group. There are editors, publishers, etc., who were against. And in this case, it's too early. We really have to see what happens. But I have the feeling that if we address countries like the next country will be Brazil, we will go to India, etc., etc. These countries are relatively strong in international negotiations today, and if they have a clear position, and interestingly also in China, we had the officials, we had people from government attending, and I'm sure that also in Brazil, people from the government will attend, and then they are much more aware that there is another perspective than what they always hear from the lobbyists.
Fred Abbott.
Well, I'm just going to start with a comment to Rito, which is that, something you said very early on struck me, which is that academics don't have very much influence in these government policy processes. And I think in the first instance, that really substantially discounts the role the Max Planck Institutes have played in the formation of European intellectual property law from the very first foundations in 1973 and before that when it was all being set up, and throughout the history and the redrafting of the European patent and so forth. And then if you're taking even your own China reference to the role you played with the development of Chinese intellectual property law and Chinese competition law and so forth. So, maybe you're talking about some kind of apples and oranges here, but I think that there's a lot of academics who have a lot of influence in how governments make policy, and the Max Planck Institute has been an exemplar of that on one side. My kind of observation goes to Rochelle, and she and I are like-minded on many of these subjects, particularly on ISDS, for example. But to my mind, I'm not exactly sure what you're getting at on the international exhaustion question. And to my mind, you're in a way going about it backwards. There's a generalized problem, and always has been for the developing countries, which is why they wanted international exhaustion during the initial year-round negotiations, which is they are frequently recipients and are licensees of northern-based technology and operate their own manufacturing facilities, which are low-cost production centers for goods. And when you block imports from those industries through a prohibition against international exhaustion, you can have an actually fairly dramatic effect on the structure of global trade and industry as a whole. When you look at specific cases, pharmaceuticals in particular, where this is a big issue, and where, for example, your namesake judge on the Federal Circuit, has been quite adamant, I think, of wanting to preserve the rule of national exhaustion for the United States, and kind of basing it on the developing country problem. There, I think there are issues that can be looked at through sui generis rules, including sui generis rules adopted both by exporting countries and by importing countries, if, for example, you have programs designed to facilitate the low-cost production and distribution of medicines in less developed or least developed countries. But I think, in a way, if one's looking at kind of getting rid of international exhaustion to solve a problem in pharmaceuticals, it's a bit of the tail wagging the dog on how that system should work, although indeed the Federal Circuit seemed to be, at least some judges of the Federal Circuit seem to be expressing that opinion.
Well, I just look at Kurtzang. So Kurtzang says we have international exhaustion of copyright. The next day, John Wiley announced a price increase of those books. So who's that good for? I mean, people at Cornell get them a tiny bit cheaper, and everybody in Thailand has to pay more than they can afford. That's not a good rule.
And the question that
Yeah.
Rochelle's answering,
Oh, sorry.
after some very complimentary observations about the leadership of the Max Planck Institute was, is eliminating international exhaustion really going to be helpful for the developing world? Or does Rochelle's suggestion sort of have it backwards?
Well, for developing countries, there's very rarely a cheaper place where they can buy things, right? I mean, they need to have things cheaper, which means they either need to issue a compulsory license, or they need to get a special waiver under the TRIPS agreement, or they need to get the patentee to agree to charge less for their own country. There's not another country where they can get it that's hugely cheaper, usually, right?
Well, your thesis
I mean,
is
some,
that-
so India sometimes doesn't have patents on certain things, but then most of the other countries don't have patents on those same things too. So then they don't need to worry about it.
Well, that goes to the issue, the second issue you raised, which is the kind of the consent theory versus the, lawfully manufactured theory, or lawfully placed on the market theory. So Carlos Correa, for example, is an advocate of the.
Oh, he
lawfully
planted these
placed on
things
the
right in
market.
this
Well,
declaration, but.
He and I have worked together
Yeah,
since the
yeah,
beginning of
yeah,
time, and so
yeah.
I'm familiar with it. But, in that regard also, the United States and the European Union have always followed the consent theory, and I doubt very seriously that they're planning in any sense to get away from the consent theory.
Oh, I think the United States, but there are countries now that define international exhaustion as if you buy the goods lawfully on the market in another country, you can bring them into your market. And I don't think that's right, that nothing's exhausted then, right?
But then again,
Right.
let's say you could have variable rules. And I'm not an advocate for the non-consent theory, but you could have variable rules, but if it weren't put on the market with consent in a developing country, and the U.S. recognized only a consent theory, then that wouldn't actually affect the U.S. market, it would affect other markets, other developing country markets. So.
Yeah, but it just depends. So New Zealand likes international exhaustion. New Zealand can afford to pay the prices for these things.
Well,
They
that's
say
the-
it's important for them
that's
because
the
it creates
top of the
greater,
theory, which I
right?
just don't
Right.
think is true.
But look at the Doha Declaration. I mean, the Doha Declaration gets implemented only because there's an agreement that these drugs are not going to be flood northern markets, and we're going to make sure that that doesn't happen. So, any time to get movement on these things, you almost always need to have some promise that the goods that are available in the cheaper in the cheaper market don't wind up undermining the price in the more expensive market. And, in fact, socially, it's a good rule. I mean,
Now you're really conflating history, because the Doha Declaration came about because the major pharmaceutical companies were charging excessive prices for these products in these less.
Yeah, I'm not
developed
talking about why it
markets.
came about, I'm talking about the result. The result, I mean,
Well,
the
so
rule that was
today, so-
implemented is a rule that prevents the spillover of these drugs back to the north.
Only because of the pressure placed on the multinational pharmaceutical industry by the whole Doha blowout. So, I mean, it's an interesting problem, but I don't think you've got exhausted.
Let me try and get one more question.
Thank you,
Sean,
sir.
did you have something before the break?
If there's time, yeah, so, so I wanted to follow up, Rochelle, because you mentioned the Eli Lilly case. And when I read the passage in the declaration that you were critiquing of tying the patent rights to the function, the specific function authorized, isn't that what's being criticized in the Eli Lilly case?
No, the Lilly case isn't about that.
Et cetera.
Now, the Eli
So
Lilly
it's
case
the
is
question
about the
the
utility.
Eli Lilly case in Canada.
Yeah, so the Eli Lilly case, the complaint that Eli Lilly is making is that Canada changed its utility requirement. Some of these are selection patents, but it happens in those cases for good reasons, but that's not the claim. The claim is that you can't change the utility requirement. Canada didn't really have a utility requirement. I mean, at some level, of course, a patent has to have a use, but patent holders did not have to expressly claim a utility, and examiners would figure out what the utility was and make sure it had it. So the court then says, this is the doctrine. The doctrine is that we have to look at the patent, figure out what the promise of the patent is, that is what the utility is, and make sure that that utility exists across the entire range of the claim. So it's kind of a little bit of a combination of our utility requirement and our enablement requirement. It sort of mushes those two together. And Lilly says, look at our US utility. How do we measure whether Canada is compliant or not? So one of their arguments is they have to have the utility requirement they had in 1996 or whenever it was that NAFTA went into effect. They can't change it. So that's the one I was talking about. Another argument that they make is, how do we know that Canada is correct? We'll look at what Mexico and the US have, and if Canada's is an outlier, then it must be wrong. So Mexican law, go figure that out. US law, they look only at the cases that do nothing but interpret Section 101. To get a patent, you have to have use. They don't look at the cases under Section 1012, which say you have to enable use and you have to enable making of the patented invention. And so they miss the part of our enablement requirement that makes sure that the patent has a use across the entire claim. But it's not about anything that's, the thing that the declaration goes to is this question of whether you can change your requirements over time. It's just outrageous that Lilly makes this argument, since Lilly basically brought all these cases that changed our written description requirement, and yet it tells Canada, oh no, you can't make any changes. And of course, they're relying on our utility requirement as of, after In re Brana, which was decided during the time that NAFTA was being negotiated. But put that to one side. But it's not about the second, some of these patents are second use patents, but that's not terribly relevant to what the claim is in the case.
So I think that takes us up to our break time. For those who are viewing us remotely, we'll be back at 10:40. For those who are here with us physically, there should be some coffee and the refreshments outside. And if I could ask the speakers to gather up front briefly during the break for a little photography, and join me in thanking our first two speakers who got us off to a great start.
So Graham tried to stream it. He says that this is the 6-hour delay.
this is like C-SPAN, right? I'm sure millions of people are waiting, right, for us to go live. So, welcome everybody. I'm Greg Schaefer. I professor of international law here, and I direct our Center on Globalization Law and Society, or GLASS. And it's and I also I dabble in intellectual property issues. It's actually, this is quite interesting to me because I'm a member of something called the International Panel on Social Progress, IPSP, out of Princeton and Paris, which is looking at sort of this different issues in global governance. And I'm on a panel called Supranational Organizations and Technologies of Governance, looking at their pathologies and their potential, which is very relevant to this panel and to this conference. And actually, Ruth Okediji, a good friend of mine when I was at University of Minnesota, is working with me on working on IP issues in this as one of our many case studies. So what we have here is two different applications of the Declaration on patent protection, applying it. First, Margot Bagley from the University of Virginia will be looking at the issue of genetic resource disclosure of origin requirements in TRIPS. And then Marketa Trimble of UNLV will be looking at patent working requirements. Both of these are issues of importance for many developing countries, and they have been contested by the global north, and particularly the United States. And so it'll be quite interesting to see what they have to say. So Margot, we'll start with Margot.
Thanks, Greg. And thanks to Dan for organizing this conference on this important topic and inviting me to speak, and Vito and the Max Planck Institute for developing the declaration, which I think makes a very important contribution to the literature, and not just to the literature, but as Rochelle was noting, has the potential to be very useful to countries, and I guess as Rita mentioned, is useful to countries already. I want to apologize in advance for the possible incoherence in my presentation. I changed my talk yesterday pretty much on the plane on my way here from Geneva, so I have too many slides, and so I'm going to zoom through a variety. I will make my slides available if you want to look at any of them in closer detail. Also possible incoherence from the fact that I've had about 5 hours total sleep in the past 60 hours, literally, and so my brain's not clicking quite the way that it should, but we're going to push on through. So the title that I have now, a little different from the show and tell, but Genetic Resource Disclosure of Origin Requirements, TRIPS, and Procedural IP Treaties. And the Procedural IP Treaties is the part that I really have added. I'll start with a very quick background because everyone is not necessarily an expert in all of these different areas of IP, but on genetic resource disclosure of origin requirements, where they've come from, the provision in the Declaration on Patent Sovereignty that relates to that, and the possible issues with TRIPS, and then looking at the DLO requirements in relation to the PCT and the draft design law treaty, which is currently being negotiated at WIPO and the Standing Committee on Trademarks. Okay, so just as background on disclosure of origin requirements, to start, it's hard to know where to start. I'll just start with the CBD, which is the Convention on Biological Diversity, which basically says that states, excuse me, have sovereign control over the genetic resources within their borders. Genetic resources are not the common heritage of mankind for anyone freely to use, but you need to get permission, and that should be made available by states on mutually agreed terms, and there should be a fair and equitable sharing of the benefits that are derived from use of the genetic resources. And a number of countries I've got there are party to the CBD. A number of countries implemented it in a variety of different ways, but one part of the CBD, it's certainly an environmental biodiversity treaty, but it also was aimed to get at the issue or the problem, perceived problem of biopiracy, and this is the patenting of genetic resource-based inventions, patents on life, without providing compensation or sharing of the benefits from the countries, the indigenous groups, the local communities that might have shared knowledge in relation to the plants perhaps that were used during ethnobiological or ethnobotanical research processes. This is from a Sanofi group paper on biodiversity and biopiracy fact sheet and what Sanofi is doing to make sure that they are not engaging in biopiracy. But they note that over time, several decades, that many compounds have been marketed, have come from substances found in nature. There's a lot of natural products research going on. The study I looked at from a couple of years ago says that perhaps 15% of plants have been examined for biological activity, maybe 1% of microorganisms, so there's still lots to learn. And researchers are being accused of engaging in biopiracy still today. This is from a 2013 publication by Third World Network, and these were just 3 of the examples they gave. So one of the ways that countries seek to comply with the Convention on Biological Diversity and hopefully to get at some of the biopiracy or misappropriation, it's perhaps a less pejorative term, is to require that patent applicants disclose the origin of genetic resources used in creating their inventions. And this list is from a report by the Queen Mary Institute from 2004. It's sort of the reasons, it's perceived unfairness that the IP system, the traditional IP system, favors certain types of innovation and creativity over others, values certain types of creativity over others, and that there's a lot of economic potential and value that's being provided by the Global South that they are not actually being able to benefit from and share in. And so by requiring patent applicants to disclose excuse me, the origin of genetic resources, it may be possible for countries to figure out if prior informed consent was obtained, if an access and benefit sharing agreement was actually entered into, or whether some sort of compensation is due. The CBD said that these things need to happen. It didn't say how to do it. So last year, another agreement came into effect, which is the Nagoya Protocol to the CBD. It provides a framework for access and benefit sharing. It has a variety of provisions. One, it does obligate parties to designate compliance checkpoints. It doesn't say what they are, but part of the discussions during the negotiations was that, well, patent offices would be good checkpoints to make sure that researchers have complied with their Nagoya Protocol obligations at the time that they're filing a patent application. So that's one possibility. And countries are supposed to cooperate with each other where another party's domestic ABS legislation, access and benefit sharing legislation, has been violated. All right, so disclosure of origin requirements, it's not going to protect genetic resource. Sometimes that language is used, but the idea is that it could facilitate access and benefit sharing, make the system more transparent, make it possible to figure out what's going on, and also provide an impetus for researchers to use best practices in acquiring genetic resources and entering into access and benefit sharing agreements. All right. There are different kinds of disclosure requirements that you could create and that countries actually use. In the EU Biotech Directive, there's an optional requirement. If you don't comply, there's really no impact. There are countries that have weak requirements where you have to disclose, and if you don't or you lie, then you would basically be punished outside of the patent system. You could have civil penalties or perhaps even criminal penalties, but the patent remains intact. Or there could be a strong requirement in, for example, China, where noncompliance results in a denial of the patent, loss of the patent. And then Brazil, for example, combines 2 or 3. There are various options that the government could choose to revoke the patent or could choose to impose benefit sharing, various things. All right, so the Declaration on Patent Protection, Regulatory Sovereignty under TRIPS, I think it's very important in terms of articulating policy space, flexibilities for countries, for developing countries. And it has a statement about disclosure of origin. It says states are not prevented from making the grant of a patent, subject to revealing the origin of claimed biological material and associated traditional knowledge. I tend to agree with that statement, but there's not explicit support for how that statement was arrived at in the Declaration, and commentators do disagree on this. And there are countries that are still unsure. I gave a talk at WIPO this summer, and one of the questions I received from the audience from a developing country delegate was, can we actually have a disclosure of origin requirement and still comply with our TRIPS obligations? So there's still a lack of clarity about whether this is allowable. In terms of the conflicting, the conflicting commentators, Nuno Perez de Carvalho wrote back in 2000 that a disclosure of origin requirement that would allow for revocation of patentability is not compatible with Article 27.1 of TRIPS, that conflicts with the obligations imposed on WTO members by the TRIPS requirement, and that's not basically allowable. Josh Sarnoff has written alternatively that actually these provisions are fully consistent with international patent law treaties, including TRIPS. Nothing in these agreements prohibits it. So bottom line is there's a difference in view. And Professor Cynthia Ho wrote a very detailed analysis for the CBD, I believe it was, a report on disclosure of origin, and looking at the TRIPS agreement, PCT, various other agreements, and how they might be able to be amended to actually provide clarity on whether or not this is allowable or not. So the declaration is helpful. A clear amendment of TRIPS would be even better. Something like that was tried in 2008. It did not succeed. But the bottom line is we don't have any clear decision yet. There hasn't been a WTO challenge on this basis, but countries are continuing to include disclosure of origin requirements in their laws, varying types of disclosure of origin requirements. China, as I mentioned, has what we would call a strong disclosure of origin requirement. No patent shall be granted if genetic resources are used in violation of administrative regulations and an invention is created on that basis. Interestingly, China is one of the few countries that we have a significant amount of data points regarding how this disclosure of if it isn't filed, a patent examiner can request the applicant to provide the genetic resource source form. They've received around 7,000, which seems like a lot, but considering the total number of patent applications, it's actually not necessarily that many. But importantly, these patent attorneys noted that this requirement is not placing an undue burden on patent applicants having to comply with this. They just have to comply, and it's not resulting in lots of rejections, things of that nature. So that's helpful. But nevertheless, it would be helpful more broadly to have clarity on the full scope of flexibility that countries have in relation to the kind of disclosure of origin requirement that they can include. And it would also help for WIPO IGC genetic resource negotiations. So this is the reason why I largely changed my talk. So at WIPO, World Intellectual Property Organization, there's the Intergovernmental Committee on Intellectual Property, Genetic Resources, Traditional Knowledge, and Folklore, or traditional cultural expressions, that has been working for the past 15 years to come up with legal and text-based negotiations since 2009 on one or more international legal instruments on the protection of genetic resources, traditional knowledge, traditional cultural expressions. As I mentioned, for GR, it really wouldn't be protection, but facilitating transparency, facilitating access and benefit sharing. And I just want to focus on the GR text for a moment. The idea behind this effort at WIPO is to promote innovation and creativity, prevent or at least minimize misappropriation, and bring some balance into the IP system. Again, as I mentioned earlier, there's this sense that there's a lack of fairness, a lack of appreciation and proper valuing of certain types of creativity that do not fit well within the traditional IP categories. So I've been working as an expert advisor to the government of Mozambique at WIPO in the IGC negotiations and in the Standing Committee on Trademark Negotiations. Rita Kedeji, who Greg mentioned, is my partner in crime there. She is on the Nigerian delegation. We are there are a few professors who are involved in these negotiations. It's fascinating and quite interesting work, and actually providing expert assistance to the African group more broadly. So yesterday at 5:48 a.m., the WIPO General Assemblies ended. 5:48 a.m., which is why I am fairly incoherent right now, because we were up all night, and apparently they do this. They just can't get agreement until the very last minute. And so the chair of the plenary is like, he's asking for agreement. It's like, well, give us 5 minutes. And you see all these groups, the EU, they go all out and meet, and then they come and make a proposal to the African group and goes out and meet, and it's just insane. Nevertheless, ultimately an agreement was reached. A very important agreement that was reached was to renew the IGC mandate. So if any of you are following this, you would know that the IGC has basically been on a hiatus this past year because at last year's General Assemblies there was not an agreement on a work program for this year. And it made it very difficult to restart negotiations, but we did get a mandate for the 2016-2017 biennium to have text-based negotiations working towards an international agreement without prejudging the outcome of whether it will be binding or not. But this was coupled, explicitly coupled, a coupling that was made by the EU and the Central European and Baltic states, with a diplomatic conference on the design law treaty that's being negotiated in the Standing Committee on Trademarks, Industrial Designs, and Geographical Indications. The African group agreed for DLT in DIPCON on the DLT in 2017. And why these two ended up getting related is because in November of last year, the African group inserted a provision into the draft design law treaty text, a disclosure of origin provision. The design law treaty, the design law treaty is labeled a formalities treaty, like PCT, like the patent law treaty, to make it easier for applicants to file design applications around the world by limiting the number of items that a country can require an applicant to submit in their application. So it has a closed list of application requirements, and very clearly called a formality treaty. But formalities treaties can have substantive impacts, and it's a concern, all right, for the African group and some other developing countries, because designs, it can be protected as industrial designs, could be based on traditional cultural expressions, traditional knowledge, even genetic resources could be used to create them. And the term of protection for designs is not long enough or not suitable for indigenous groups. Okay, we'll get into why it's more than just a formalities treaty, or some of its implications that developing countries are concerned about, but it has a number of very important implications. And this, draft Article 3, is the closed list of items that a country can ask an applicant to include in their application. And it doesn't say anything about disclosure of origin. So the African group introduced a provision, and I don't have time to get into now the language. It actually would be a mandatory disclosure of origin requirement. The African group has specified that they are very willing to move on that language, but they want to deal with the question of disclosure of origin in the design law treaty. And it's important. So mentioning the Patent Cooperation Treaty, which basically makes it easier to file patent applications in multiple countries. The PCT says that national law, and this is from Cynthia's report, she put in a nice table, may require the applicant furnish evidence in respect of substantive conditions of patentability. And then it specifically says things that a country can require, but it's not clear on whether you can actually do disclosure of origin. So that actually has been a contentious issue in relation to the PCT and the PLT. And Switzerland, on a number of occasions, has proposed an amendment to the PCT to make it clear that countries can require disclosure of origin. So one of the challenges, countries like Switzerland, Norway, some other countries that have imposed a disclosure of origin requirement only apply it to national applications. They don't apply it to PCT applications. And that's going to impact the national experiences, the data points. I mentioned China have a number of data points. Well, Switzerland and Norway, they have small national offices. Most of the patents that are going to be granted in Switzerland are going to be based on PCT applications or going through the European Patent Office, whereas I said it's not a mandatory disclosure requirement. So these procedural treaties have this impact on disclosure of origin if countries are not sure whether they can actually require this or not. All right, I'm about out of time. Right, so yeah, it's unclear what happens in the national phase. We need kind of a declaration, as it were, on whether countries, in relation to procedural provisions, can require disclosure of origin. And to the extent that treaties like the PCT say that countries can require things related to substantive conditions of patentability, well, that creates a different problem, because part of the negotiations at WIPO on the IGCGR text, developed countries, the EU, United States, et cetera, are saying we do not want, if there's going to be a disclosure of origin requirement, it shouldn't be tied to revocation, okay? It should be like Switzerland or Norway, which is non-substantive, okay? But if you can only in a procedural treaty require things that relate to substantive provisions, then that would push towards patent revocation as the penalty for not complying with the DOO provision in the GR treaty. So there's actually a conflict there. So, and I encourage you to ask questions, because I realize I'm presenting a lot here, and especially if you're not familiar with the Design Law Treaty, this might be a little new and different. But the Declaration also states that states should retain the discretion to adopt a patent system that best suits their capabilities. And having the flexibility to require disclosure of origin is an important flexibility. So to conclude, articulating patent flexibilities for TRIPS, that is an important benefit for member states that the Declaration works to provide. It could be improved, particularly in relation to the disclosure of origin, so specifying why there is consistency there and which kinds of disclosure of origin requirements are consistent with TRIPS. Formalities treaties beyond TRIPS can impact flexibility in important ways, are contributing to a lack of national experiences, which is another tension point in these IGC negotiations with countries saying, well, we need national experiences to know why we should be doing this. And if you have these treaties that are preventing the number of applications from being, including disclosure of origin, that's a problem for getting national experiences. And formalities treaties, finally, may unintentionally channel DOO requirements more towards substantive patentability requirements, which arguably may not be what we want to do. All right, so with that, I will close. Thank you.
Thank you. And our next speaker will be Marquetta Trimble. Continue. And she'll be speaking on patent working requirements.
Good morning. I would like to thank you for the invitation to present here today. I will speak about patent working requirements. Patent working requirements are mentioned in the Declaration on Patent Protection. If you turn to page 9, in paragraph 30, you will find language concerning, the comment concerning compulsory licenses for failure to work, which would mean patent working requirements. So there has been some renewed interest in patent working requirements for two primary reasons. Number one is that as least developed countries are being pushed to increase the level of patent protection, they will naturally look for ways to mitigate some of the negative effects that this increased patent protection might generate. Patent working requirements are certainly types of provisions and arrangements that can help mitigate some of these negative effects. The second reason is US specific, which is that the United States faces this phenomenon of patent trolls that is also familiar to our European colleagues, but is not as prominent over there. And some commentators have looked at patent working requirements in various countries as a source of inspiration for some kind of provision that might be introduced in the United States to, again, mitigate the negative effects of so-called patent assertion entities or patent trolls, simply companies or entities that are actually not practicing the patent that they try to enforce. So today, I will talk briefly about the history of the working requirements, their functions, and their relationship to other components of national patent systems. One of the problems that I found when I looked at the literature that's coming out now in the United States about patent working requirements is that the literature typically takes the discussion of these requirements out of their context, the context of national legal systems in which these working requirements operate. So, definition. When we talk about patent working requirements, let me define them at the beginning so that I hopefully prevent some misunderstandings. I am talking about provisions that mandate that an owner of a patent must practice his patented invention, meaning either manufacture or at least import the invention within or to the country that granted the patent. The remedy for failure to do so vis-à-vis society and the sanction vis-à-vis the patent owner for non-working is either forfeiture or a compulsory license. National working requirements, not surprisingly, evolved throughout the history and, as has been mentioned earlier today, of course changed and were shaped in various ways depending on countries' needs and various functions that these working requirements were sought to fulfill. In the United States, we often claim that we have no patent working requirement, which might be a little misleading, but there was a patent working requirement per se in the United States between 1832 and 1836. It was very limited. It only concerned foreign patent owners. As some of you might know, in 1908, in a very famous United States Supreme Court, the Supreme Court confirmed that there has been no patent working requirement in the United States since 1836, and that even equitable considerations don't really encompass any kind of working requirement per se. However, there are certainly features in the United States patent system that resemble patent working requirements. We can certainly think of the provision on the preference for US industry in terms of federally funded inventions, or the provision on the manufacture in the United States under Section 209B, where, again, federally owned patent should be licensed, exclusively licensed, only if the invention will be manufactured substantially in the United States. In addition to that, there are other provisions in US law that encourage, even strongly encourage, working in the United States. If you think of the recent decisions by ITC, again, that involved non-practicing entities, we see there certain pressure for patent working. So why to look at the history of patent working requirements? Well, the history and its overview will help us understand the various functions that patent working requirements used to fulfill and in some countries are still needed to fulfill. So the very early predecessors of working requirements are to be found in the very oldest patents, actually medieval and early modern patents. As early as 1331, we know of a patent issued and granted in England where the king promised to grant similar privileges to any other foreigners who will come to Great Britain and settle there and teach their arts to those willing to learn. We see that patent working requirements were maintained in those old patents and they developed. In fact, later patents in England, for instance, already included a threat of invalidation. So they specifically said, if you don't continue practicing your patent in England, we will invalidate this patent. And fascinating is that in 1639, we have apparently the first patent recorded that included a provision that the patent must be worked within 3 years, otherwise it will be invalidated. So we have the 3-year period that we know from later versions of the Paris Convention included in a patent from the 17th century. In the protectionist period of the national patent systems, let's call it the period before international negotiations on patents were resulted in first convention, the Paris Convention, there was, of course, a very great focus on benefit to the local industry. So some countries actually even denied originally patents to foreigners at all. Other countries had working requirements and would actually not allow those working requirements to be satisfied through importation. So you actually really had to manufacture in the country. Again, in the United States, we had the short period of working requirement in the 19th century. The Paris Convention, when it was signed in 1883, already faced some disagreement about patent working requirements. As a matter of fact, before the convention was signed, 4 countries objected to patent working requirements being de facto enabled by the convention. Countries eventually settled on the text, according to which working requirements were considered a matter of national law. Every country was free to do whatever it wanted. But also another provision was included that no forfeiture for importation from one of the Paris Union countries to another should exist. Now, there were multiple revision conferences, and patent working requirement was clearly a contentious issue during the negotiations. Countries share different views on whether working requirements should exist, whether forfeiture should be the sanction to be imposed for non-working. But it seemed like countries were liberalizing their patent working requirements and things were becoming easier for patent owners. Nevertheless, at the beginning of the 20th century, the United Kingdom actually strengthened and tightened its patent working requirement through statutes adopted in 1902, 1907. Interestingly, the statute in 1907 followed a parliamentary debate in which it was pointed out that more than half of the patents granted in 1906 in the United Kingdom was granted to foreign patent applicants. And undeniably, big excitement was caused by the fact that a lot of the chemical patents that were granted to German chemical companies. So it was viewed by the United Kingdom as a possible threat to its own chemical industry that a lot of the patents in that area were actually held by German companies. Germany, on the other hand, also under the pressure of its own chemical industry, sought ways to improve the situation and to lighten patent working requirements by concluding bilateral treaties with several countries, including the United States, according to which patent working was sufficient as long as the working occurred in one of the contracting countries. Patent working requirements returned to the negotiation table in the 1970s and 1980s when a new revision of the Paris Convention was being negotiated. There, the developing countries brought new proposal how to deal with working requirements, asking virtually to tighten working requirements, make it allowable for countries to disallow importation as a form of compliance with the working requirements. And indeed, this proposal was one of the reasons why this revision, the latest attempted revision of the Paris Convention, didn't come through. So what happened post-Paris Convention revisions? Well, at the end of the 1980s, the European Commission brought Italy and the United Kingdom to the Court of Justice of the European Communities at that time because of Italian and UK working requirements that the court at the end indeed held to be contrary to Article 30, at that time Article 30 of the treaty establishing the European Economic Community. So it was held that these working requirements within the European Union at least represented quantitative restrictions on importation that had negative effect on free movement of goods. The TRIPS agreement doesn't specifically address patent working requirements, but as is obvious from the declaration, page 9, paragraph 30, and also from other discussions, it's really not clear what the TRIPS agreement actually means for patent working requirements. There are commentators who argue that Article 27.1 of the TRIPS agreement completely prohibits any kind of patent working requirements. Other commentators suggest that the Article 27.1 is not against patent working requirements completely, but at least mandates that countries recognize importation as one of the possible ways to comply with patent working requirements. We don't really have any authoritative interpretation of what should happen to patent working requirements under Article 27.1 because the US-Brazil dispute that was raised in 2000 didn't really result in an opinion, a binding opinion. It was settled, but yet it is, and that's primarily the reason why it is extremely valuable that the declaration decided to address this issue as well. So what are the functions of working requirements? And again, the history, of course, helps us to understand how various countries at various stages of development used patent working requirements to pursue different goals. So function number one is disclosure, right? The idea, the sort of medieval idea that a patent is granted to an inventor or to a patent holder to bring new technology, new knowledge into the country. We are talking about a situation in which there's no manufacturing capacity in the country. There's not even an industry related closely enough to the invention that's being brought in. We want the patent owner, patent holder to come in and teach the nation, right? In the old days, inventors were thought of as teachers of the nation. So this is indeed a very important informational function that working requirements served and in some countries will still serve. Another one, and the one that we often think of maybe first, is the protection or promotion of the domestic industry. So certainly to the extent that countries had or still have patent working requirements that cannot be met through importation. Patent working requirement, to the extent that would require manufacturing in the country, helps to build local production. It helps to build up infrastructure in the country. It certainly has an effect on employment in the country, on creating, educating newly skilled labor force. So that's another very important function of working requirements. And of course, we can think about whether this function can be really met, can be fulfilled if we allow importation to actually satisfy working requirements. Another important function is access. There will be situations, countries and industries, where the country really cares about access, immediate access to patented product. The country might not necessarily pursue development of the entire industry in that field of technology. It might not care, it might not have any reason to, but wants to secure access of its population to the patented invention. That's another important function. And of course, for this function, we understand that importation is just as good for complying with patent working requirement as local manufacture. Importation would too secure access to the patented invention. It also relates to the protection against blocking monopolies. Certainly countries might be looking at patent working requirement to prevent certain industries, certain companies, for actually blocking innovation in the country. To the extent that the country already has sufficient industrial capacity or manufacturing capacity in that area of technology, it might be well capable of developing new inventions in the vicinity of the patent, but of course it doesn't want its development to be blocked in that manner. And finally, something that might relate to the situation in the United Kingdom in the earlier 20th century is the concern about strategic uses or national security, if you want to call it, the need to preserve or develop a field of science or technology in the country. And of course, this is a very tricky issue because we don't talk here necessarily about monopolization by one country or one country industry, as we saw in the historical example, but we can also think about instances when monopolization is threatened from one patent owner, patent pool, or a group of somehow related patent owners, and situation where there is the patent is formally worked in the country because those patent owners have their manufacturing capacities in the country, but the country is not really developing the industry in any other way. There's no alternative, no competitor in the country, and there's theoretically a possibility that the country could be shut off, at least for some period of time, from the technology that it desires to have access to. Now, the different functions of the patent working requirements exist in various countries at various times. Emphasis will be put on different functions in different countries. An important aspect is, though, that patent working requirements don't really operate in isolation. Like any other component of patent systems, they are embedded in a very complex system, which is the patent system, and work differently in different countries. Some countries might need them more than others. So let's talk about some of these components of national patent systems and how they interact with patent working requirements. Perhaps a mundane point is relationship, the link with patentability. Because if a country finds a way to exclude certain patentable subject matter, certain types of inventions from patentability, the need for patent working requirement arguably diminishes, at least as to that particular type of invention. And Professor Dreyfus mentioned several ways in which countries try to limit the scope of patentable subject matter, for instance, in the areas of pharmaceuticals today. So, notwithstanding the fact that we have the TRIPS agreement that aligned rules on patentable subject matter to a great degree, countries are still finding ways to limit patentability. Another relationship, of course, exists with disclosure requirements. So patent working requirement as the vehicle to teach the nation, right, to teach local population about the invention pretty much disappeared in light of sophisticated disclosure requirements that modern patent systems developed. Notwithstanding that, of course, we do see remnants of working requirements still surviving in many national patent systems. Exhaustion doctrine was covered at great depth here too, Again, it's interesting to think about the relationship of patent working requirement and principle of exhaustion. Certainly to the extent that a country might be more concerned about access to patented products rather than developing its own industry, it might adopt a different approach to the exhaustion doctrine than a country that actually cares more about developing its own native industry. Injunctive relief, something that has not been very discussed in the United States, but is a very interesting point. We sometimes forget that not all countries allow courts or give courts discretion to deny injunctive relief. Civil law systems, such as Germany, for instance, might have discretion for courts in cases of preliminary injunctions, but for permanent injunctions, it's clear rule: if you have a valid patent, or patent that's likely valid, and it is infringed, you grant injunction. For those countries, patent working requirement might serve a very important role in their overall legal system because they don't have the tool that we have in the United States for courts to consider non-working when they decide whether to grant or not, whether to grant or not to grant injunctive relief. And finally, there is naturally an important link between patent working requirements and competition law. And I know that Professor Abbott will talk more about competition law, so I don't want to go into details. But certainly, there are limits on what competition law can solve in terms of remedying non-working of a patent. Some countries have the system of license of right. You can have your patent designated license of right, which actually interestingly draws these patents into a system that's very similar to standard essential patents in the United States and other countries, meaning it is a tool that allows patent owners to be protected from attacks for non-working, but also imposes an obligation on these patent owners to license their patents on front terms. So what to conclude? Well, I think as everyone in the audience appreciates after our two presentations early this morning, patent working requirements are important in some countries, and in some countries more than others. When we think about patent working requirements, we should not think about comparing provision to a provision word by word. As with any other component of legal system and with any other comparisons, we have to look at the functional level and think about all the consequences that the provision has in that given national patent system and how it interacts with other components of the legal system. It also, this comparison shows that there can be serious problems when international treaties aim for very specific wording, for very specific language, and the level of specificity might lead countries to adopt the language of the treaty. Doing that can, of course, result not only in an unwanted negative effect of a transplant, unfortunate transplant, but it also raises other problems, and the functioning of the entire legal system might be actually weakened by it. Of course, there are good reasons to put specific legal provisions in the treaties, and as Professor Dreyfus pointed out, when it's good for the legislator, they will look at international treaty when they need to substantiate and explain certain legislative steps. At the same time, though, for the executives, it's very good approach to aim for very specific wordings in international treaties, not only to achieve a high level of harmonization, but because in some countries, and the United States is not one of them, but in some countries, even international intellectual property treaties can be directly applicable as long as the language is specific enough and other conditions are met. So to the extent that international law still permits working requirements, some countries may and should use working requirements to address issues that other countries may actually quite easily solve through other mechanisms. So going back to Professor Burke's opening remarks, one size probably doesn't fit all. Thank you very much.
Hey, Barco, come on up. Arcade, I think we're right here.
Thank you.
I hope we can fix this. At least that's better than being on a slant. Great. So I'm going to open it up to the floor, but maybe just first I was wondering, Margot, if you could talk a little bit about on these process treaties, the political economy of it. Who's resistant to recognizing or recognizing the ability to require disclosure, and what are the grounds for that resistance in these particular treaties? Given that at least the European, it sounds like Switzerland and Norway are proponents of inclusion, and the EU certainly is a signatory and has ratified the CBD and the Nagoya Protocol.
So, how can I say this and still be diplomatic? Switzerland, excuse me, is not part of the EU, and the EU, as I mentioned, the biotech directive, excuse me, has a disclosure requirement, but it has no teeth to it at all. And while it is true that the EU is party to the CBD and Nagoya and has a directive on implementing Nagoya, the EU is not particularly in favor of disclosure requirements in the Design Law Treaty. And the position, I'm not going to try to get into the whys. I will say that specifically for the Design Law Treaty, one concern, and this I understand, is that the treaty text itself was fairly mature. There had been agreement among most parties to the various provisions. And so for the African group to insert it in November, the EU went at a diplomatic conference this year, actually in 2015. And so now it's being pushed off to the earliest, early 2017. So part was timing, and then there has been, the EU has been on the record in the IGC negotiations in terms of not wanting any sort of a binding agreement in relation to GRs, TK, or TCEs. So that's a big part of where the resistance is coming from. Japan as well. The U.S. has been a bit more pragmatic with the Design Law Treaty, but there's special things going on between the U.S. and the EU right now because of the Lisbon Agreement. And so this was okay, I think I'll just stop and leave that there.
Okay. Open it up. Yeah, Dan.
Question from Marquetta. So, and we might need to repeat some of these questions that are coming from the audience because the mic may not pick it up. But you had mentioned some ITC decisions that you thought either created a pseudo working requirement or moved the U.S. in the direction of working requirement. Would you say a little bit more about those decisions or how they work?
You want me to repeat the question, or are we?
Marquetta can.
Okay.
Just
go ahead,
so
Marquetta. Yeah.
The audience at home can follow along.
So Professor Burke asked about the ITC decisions that I mentioned and how they might create a patent working requirement in the United States or move the United States in that direction. So one of the ways to propel local working, or one of the ways to promote local manufacturing or local working, is to limit the availability of certain remedies to companies that will actually practice the invention in the country, whatever the practicing de facto means. There have been some academic proposals to look at not only injunctive relief, but also damages for patent infringement in a similar manner. The International Trade Commission has issued two decisions that
I'm aware of, one from 2011 and one from 2014, in which the International Trade Commission interpreted the language of Section 1337 to really require working in the United States for the availability of the exclusion order to those entities. So again, it's not patent working requirement in the sense that if you own a US patent, you have to work it in the United States. But it is a way to encourage perhaps local working by making clear that certain remedies, in this case the exclusion order, will be available only to countries that truly practice the invention here. In the US-Brazil dispute, we know that Brazil counterclaimed in the dispute, arguing that the United States has real patent working requirements in sections 204 and 209, which are the federally funded patents. And those, I think, are more clearly in the direction of a true patent working requirement than the ITC decisions.
Great. Somebody else? Yes.
To question to Margot, I admit ignorance of your topic totally, but presumably this disclosure, when it's made, is made and has some consequence of the fact that it's made some restriction or limitation of the patent right that might be exercised in a developing country. But my question is, what if there's another country that claims the same indigenous cultural origin, but the disclosure says, we got it from Cameroon, but the neighboring Congo says, that's indigenous to us, our ecology. So is there a process of determination to determine if that is in fact the case? Does one country get to jump on whatever consequences of making the disclosure might be? How does it play out?
Right, so there are two separate issues, and that's a very good question. One is the applicant making the disclosure in the patent application. And as I mentioned, there are at least 4 kinds of disclosure regimes. So it may not actually impact the, as I said, the revocation of the patent or the enforceability of the patent. It may or it may not. But the transboundary question, where you have traditional knowledge or genetic resources that may be indigenous to more than one region, is a real issue. And that's more on the Nagoya side. So the Nagoya Protocol, Article 10, I believe it is, suggests the creation of a multilateral benefit sharing fund to address these sorts of transboundary situations. There have been reports and suggestions. They haven't come up with anything final yet. But that gets to the second side. There's disclosure, and then what do you do about disclosure? Once you find out there's disclosure, and if someone, if they said they got it from here, well, that's one question. But if another country says, well, but this is also indigenous to us, should they also have entitlement to share in any of the benefits? That's not a situation that has been fully addressed in international law yet. But one of the things that's been proposed is for in those kinds of situations where there was not, let's say there was disclosure, but the inventor did not enter in any sort of access and benefit sharing agreement, that they perhaps should put money into a fund that would be able to be distributed across countries for various types of conservation and biodiversity protection projects. This would be modeled perhaps on the International Agreement on Genetic Resources for Food and Agriculture, administered by the FAO. They have a multilateral benefit sharing mechanism, and basically there's money that goes into this fund, and then individuals or organizations from countries can submit proposals to be funded out of that fund, and all of the member countries are allowed to basically submit those kinds of proposals. So that's what's being proposed, but it's not in place yet.
So just to follow up on that, Margot, so this sort of goes back to the first question, which is, can one summarize the 2 main grounds for resistance? Is that one, if you have a mandatory disclosure, and if you don't, there could be a claim that you did not disclose, and consequently that could provide a grounds for revoking the patent. And two is that the potential that there would be a claim for sharing of the benefits. Are those the two main grounds, would you imagine, for resistance for requiring a disclosure?
Right, so thinking big picture, the bigger question about disclosure is the potential uncertainty that it creates for patent rights. Because, the original inventor who perhaps didn't comply, they get a patent, and then you've got downstream people who buy the patent later, didn't know anything about it. Are they going to lose their patent because of what someone did earlier in the chain? So that creates potentially a cloud of uncertainty if you have the possibility that the patent could be revoked on that basis. So uncertainty is definitely a concern. And other concerns are burden, it perhaps being a burden on the patent applicant to have to figure out where this came from. And the other one you mentioned is also...
Potential having to share money.
Right, that's a big one. That's a big one. The transaction costs, if you have to now negotiate benefit sharing, and your patent is perhaps held hostage because you may not be able to enforce it, or you may lose it if you don't enter into some sort of a good agreement. So yeah, all of those, are you going to have to pay money? How much are you going to have to pay? What impact is this going to have on your patent rights? And the fact that there are these different regimes. This is not a harmonized system at all. And so in some cases it is revocation. In others, it's just a normal penalty for perjury where you may just have to pay a fine. And so not knowing, having different requirements, potential burden, transaction costs, all of these are reasons to not want to.
And then in terms of the numbers of countries, you said there are over 20 now? And can one identify the countries that have actually placed this in their laws, those who have intensive natural resources, or there are a number of developing countries who are in that situation who have yet to declare? And do you think there could be a tipping point as more and more sort of say, we can do this, then that provides incentives for others to follow?
Absolutely, absolutely, especially with the coming into effect of Nagoya in October of last year. So countries are going to have to implement Nagoya. So far, at last count, 68 countries had ratified Nagoya, but very few have submitted implementing legislation to the CBD. But as I mentioned, a patent office or IP office is a logical checkpoint for compliance with Nagoya. So there's an expectation that as more and more countries draft their implementing legislation, they will include patent office as a checkpoint. They will include a disclosure of origin requirement to facilitate Nagoya. So right now the CBD for Nagoya has an access and benefit sharing clearinghouse, and I believe 4 countries have identified checkpoints to this clearinghouse, and of the 4 countries, 2 have identified patent offices as checkpoints, and both of those, of course, have disclosure of origin requirements in their laws. I mean, this is not a large data set, but the expectation is that, yes, more and more. And so it's like, go ahead and might as well do this on the international level and perhaps get some minimum standards and maybe even some ceilings, because it's a fact of life. And if China has it, and that's where China gets more patent applications than anyone else, you're going to have to deal with disclosure of origin.
Okay, Dan.
Yeah, I'm a little bit worried about Margot's voice pulling that, but I still feel compelled to.
Okay.
So I'm trying to sort out, sort of in my own mind, some of what you presented, and maybe you can clarify for me. It sounded to me like there are 2 models for limitation on disclosure, right? You said that there are, some countries that have a revocation or a penalty regime, and Brazil might even combine those. You said. I'm curious to know how that works. And then if I understood correctly, there's a separate approach. I think you said Switzerland and some other countries have, where it's sort of limited to national applications, and it was unclear as to sort of which of those are at issue or which of those are in play in the conversation that you talked about. Is it the controversy whether we should have revocation or penalties, or is it whether we should try and limit it to national, or be able to limit to national or not? Or are all of those being discussed?
Right, so that's actually a great question, Dan, and everything is being discussed, and what's been happening in terms of the IGC is the demandeurs, the largely developing countries, have had to ratchet back what they've been asking for. They originally did want revocation. I think it's unlikely that revocation would end up being included in that agreement. What we're probably going to end up with is a minimum standards agreement, require disclosure of origin and not leaving to national law what the penalty would be for non-compliance with that. So you've got India who wants to have criminal penalties, they can do it. Or if you want to have Switzerland where you just pay a fine and your patent is fine. Leaving those details to national law. That doesn't deal with the uncertainty issue, but I don't see us getting to harmonization. I really think it's going to be minimum standards.
I'll turn to patent working, and also, but if other people have questions, please let me know. It seems, looking at the declaration itself, the way it starts off, or the sort of the introductory part, is if patents are supposed to be, the system is about fostering innovation and consequently enhancing social welfare, that a patent working requirement can be used for purely protectionist purposes that have nothing to do with innovation or enhancing social welfare. You can imagine the U.S. and Europe using them against each other, or Canada using against the U.S. or Mexico or so forth, purely to have domestic investment and domestic employment and to limit trade. That's, in the way I read at least the declaration, it seems to suggest that that's completely okay under TRIPS. Whereas clearly there's also concerns with patent trolls and others about simply holding on to patents in order to extract revenue, which has nothing to do with innovation. So I was wondering, is there anything out there which tries to get at legitimate and illegitimate uses of the patent working requirement, and how this might play out in particular for developing countries?
Well, maybe 2 points. Welfare, social welfare. I think as we saw in the discussion between Professor Dreyfus and Professor Abbott, when we think about social welfare, we will have to decide whether we adopt the internationalist perspective or whether we will focus on country-by-country perspective. And of course, for businesses, for international trade, the internationalist perspective makes perfect sense. Nevertheless, we still live in a world of various countries that have their national policies, that have stakeholders that are local. From that perspective, I don't think that it's easy to look for increasing social welfare globally as much as we might think that's desirable. The situation on the ground doesn't seem to support that approach of adopting that perspective. So that's one. As far as deciding between good and bad uses of patent working requirements, patent working requirements are certainly not the only component of any legal system that can be used in both ways. And just like with other components in many other legal systems, we might not actually have to or want to look at international patent law to solve all of our problems. And there might be other ways for countries, in the worst case, to retaliate or to mitigate some of the undesirable uses of patent working requirements. But again, those components work within the systems, national legal systems, and when we evaluate their functioning, we shouldn't really lose the sight of the larger context.
Right.
If I might just contribute to Marketta's answer a little bit, because she started by saying that the WTO hasn't decided about this, and you could make a somewhat contrary argument that the Canada Pharmaceuticals case, where Bob Hudek interpreted discrimination to be a normative term, pejorative in content, and to say that when you say you can't discriminate between imported and locally produced products, what you mean is that it can't be justified, and that conversely, if it's used for a pejorative, discriminatory manner, then it might not be permitted. So you could imagine a situation in which a panel would sit and say, well, if it's because the country merely wants to use it as a disguised way to implement a national treatment derogation, that might not be a justifiable mechanism. Whereas if it were to, as the U.S. itself has said, to defend the country in the event of a pandemic and to have available local supplies, which we think is necessary, and therefore we mandated a local working requirement, that would be justifiable. So I don't think we're content-free if you look at the Canada generics decision, and I just throw that out as one way you could.
Yes, it'd be trying to get at purpose in some, which is hard to get at, but
Well,
it's what.
agreed, and you get to the question is, which is a kind of a heart of a lot of it, can building up your national infrastructure to improve your local economy a legitimate
Right,
thing you're wanting to substitute, and that's really the difference.
which goes to the heart of industrial policy and
But let me just
import
add that
substitution.
the Paris Convention was entirely neutral. I mean, the Paris Convention just said the time period expires,
Yeah.
go for it.
Mm-hmm. Yeah, yeah, Sean?
So following up on that, Marquetta, and apologies if I missed that in your presentation, but so what's your approach? The declaration takes a stronger view on that it's not just about the possibility of reasonable differentiation. Actually, the discrimination language in Article 27 doesn't apply to compulsory licenses. You can have local working requirements straight up, industrial policy or otherwise. Do you have an opinion on that part of the declaration?
So thank you for the question. The question was, could I say something that I don't say in my paper? As a matter of fact, in my paper, I emphasize that I don't take a position on what the interpretation of the TRIPS agreement should be. In my reading of the TRIPS agreement and commentaries on the TRIPS agreement, I do agree with the declaration in the sense that I think the non-discrimination provision of Article 27.1, second sentence, goes to patentability, right? Goes to availability of patent protection, but not necessarily limitations, exceptions that are possible under Article 30, 31, maybe in the future 31 bis. So that's my personal opinion. The paper that I'm writing about patent working requirements doesn't go into that debate. I don't want to open it up in the paper. It remains agnostic to that issue. And I think it's important because I think that debate often clouds our understanding of what patent working requirements actually are, what functions they should serve or might serve in various countries. So that's what my paper is trying to do.
Okay, why don't we thank our panelists and wrap up for lunch.
So for those who are out on the web, we will be breaking for lunch. We'll not be transmitting again until 1:30. And the audio, as I said, will be off so that we won't pick up the conversations that are happening here in the room. For those who are here physically, luncheon has been set up. If you go back outside, immediately out the door where you found the breakfast things, you'll find lunch has been set up. You're welcome to bring the lunch back in here. You may be able to find a seat outside, although you might have to arm wrestle some of our students for seats, but I see at least a few if you prefer to be outside. And we'll resume at 1:30. If you want to stretch your legs a little bit, look at the campus, feel free, and we'll see you back there then. Yep. Okay, welcome back to those of us here in the physical facility and also to those who are viewing this remotely. This is the second half of our program on patent sovereignty and international law, looking at different facets or aspects of patent law and how national laws interact with and accommodate international treaties on patents. The second half of our program today, we start off with Professor Donald Harris, who's joining us from Temple Law School in Philadelphia. He'll be followed by Professor Fred Abbott, who is internationally renowned expert on world trade, who will join us from Florida. Each of these two professors will speak for about 20 minutes. And then again, we will have some time to open the floor up for questions and discussion. And so we turn the time over to Professor Harris.
Great. So, like the other guests, I also want to thank Dan for inviting me. I grew up in California, and so getting the opportunity to come back here, particularly during the fall and winter months of Philadelphia, I welcome that opportunity.
We'll remember that.
Please do. Yes. So, we're talking about the Declaration on Patent Sovereignty. I actually enjoyed the chance to review this. I had not known about it before being offered the opportunity to look at it, but I think that there are a lot of good things in this. I particularly like the ultimate goal of trying to find some policy space, some discretion for states to implement patent laws and to do so more tailored to their cultural, social, economic needs, rather than having this one-size-fits-all approach that the other commentators have come up and have rejected. While I like the Declaration, I do think that there are some troublesome issues, and I raise these for a number of reasons. One, because I think that there are some inconsistencies with the law as pronounced in the Declaration and as I understand the law. So I think they're very difficult to reconcile, and so I want to point those out. But I also think part of it stems from what Rochelle was mentioning earlier today, and that's this credibility issue. I think you want an instrument that is credible, that people can look at and believe in without it having to be perceived as being biased. And so I want to direct my comments to what I see as these perceived inconsistencies. I'm going to start by talking about the various provisions. I'm not going to talk about all the provisions, simply the ones that I find troublesome. Then I'm going to say why I find them troublesome and how I perceive the law. And I do this simply by treaty interpretation. Standard canons of treaty interpretation lead me to a different place than where the Declaration ends up. Then I want to talk about some changes in the IP, in the international IP lawmaking system. We've seen plenty of changes in how we make law in international intellectual property, and I think it would be instructive for us to look at that so that we can have a different path for this Declaration. Then I want to talk about some success stories to say, yes, it is possible, and then end with some concluding remarks. The Declaration. Declaration has 12 different provisions, starting with differentiation, leading all the way to criminal measures. As I said, I'm not going to talk about all of them. Some of them, though, that I find objectionable are the ones that I underline. Differentiation, patentability and disclosure, scope of protection, exhaustion, exceptions to exclusivity, and compulsory licensing. Now, it may seem like I have objections to quite a few of these provisions, but really what it is that there's a thread that runs through each of these, and so they affect these to varying degrees. And this thread is this idea that differentiation is different than discrimination. And so I want to talk about that and talk about what we mean, what the Declaration means by that. But I think if we pull this thread, then all of these others, as I said, to varying degrees, kind of fall apart. And so I think we need to shore up that definition. What's meant by differentiation, according to the Declaration, is that states can treat different technologies differently. Why is that important? Because TRIPS says we cannot discriminate. We cannot discriminate as to field of technology. Well, if we're not discriminating but differentiating, then we're complying with TRIPS. And so this argument, this distinction between differentiation and discrimination becomes extremely important for the entire declaration. There are two schools of thought, I think, about this differentiation argument. One, the commentators believe that there is what we refer to as technological neutrality. And that is, we have to treat all technology the same. Otherwise, we're going to violate TRIPS. I don't agree with that. I reject that approach. And I reject that approach because I think that the language of TRIPS offers more flexibility than that. I don't think that the drafters of TRIPS intended to be as strict as that interpretation. And I think that at least now we have some we have a WTO opinion that is consistent by saying that these two terms are different. On the other end of the spectrum, we have what I will refer to as unfettered discretion. That is, as long as a country can justify treating different technology differently, then it's okay. It's not discrimination. And we simply need a bona fide reason for doing so. And so as long as we do so, no discrimination, comply with TRIPS. I reject that approach as well. And my view here is that there are plenty of reasons to want this approach and to adopt this approach. And I think intuitively, it sounds like the right approach. We want states to have this type of discretion. We want states to have the ability to tailor their intellectual property regimes. We want states to recognize that technology impacts society in different ways, and so we should treat technology differently. But wanting it to be so doesn't make it so. And I think that in the abstract, the argument is compelling, but when we look a little bit deeper, when you start actually analyzing what happened and place it in context in the light of TRIPS negotiating history, I think a different view emerges. This is a provision we're referring to, Article 27. Patents shall be available for any invention, whether products or processes, in all fields of technology. Patents shall be available and patent rights enjoyable without discrimination as to the place of invention, the field of technology, and whether products are imported or locally produced. This is TRIPS' non-discrimination principle. Okay. So I said, I think, though, that placing it in the context of TRIPS negotiation, we can understand what was going on here. So, I think I missed something here. Okay. Treaty interpretation. The Vienna Convention Law of Treaties. When we're interpreting a treaty, we go to the language. We look at the ordinary meaning. If there is any ambiguity as to the ordinary meaning, then we fall back on other approaches. So then we look to the negotiation history. And that's what I say we end up with here. Is the language ambiguous? Sorry, is the language ambiguous? I think it is. I think that, yes, we can say that there is a distinction, but how do we define discrimination? A WTO panel attempted to define discrimination, and in the end, they simply said, we can define it as a normative term. I think Fred pointed this out earlier, pejorative in connotation. But then they simply said, we're not going to define it any more precisely than we need to. So in this particular context, we'll define discrimination as this, but in other contexts, it might be different. And so I think that there's a strong argument that the term discrimination is ambiguous. And if so, then we look to the negotiation history, and what do we see there? Okay. The pharmaceutical industry influence. Okay. Pharmaceutical industry was concerned because states were discriminating as to their products. So one thing that they would do, states would do, they'd provide a shorter term. So 7 years, for example, rather than 20 years for pharmaceutical products. There was also a license of right. Countries could issue compulsory licenses as a right against pharmaceutical products. They had to probably pay some kind of remuneration, usually 4%, but they were able to do so. And the pharmaceutical industry spearheaded this effort to get TRIPS and this non-discrimination principle in TRIPS. Who else was an influence? the pharmaceutical industry. Again, it wasn't only the idea of discriminating as to the term of protection or as to compulsory licenses, it was also as to products versus processes. And so some countries, they granted protection for the process, but not the product. And pharmaceutical companies said, no, we do not want this type of discrimination. And so you see in Article 27, no discrimination as to products or processes. Who else was involved? Again, no big surprise here. Who I'm pointing to, the pharmaceutical industry again. And here it was more fundamental. What they said is you cannot discriminate by not providing protection at all. And so some countries, for legitimate reasons, would say we are not going to provide patent protection. It's in our public interest not to provide patent protection. So there was no patent protection on pharmaceuticals, on foods, chemicals. And so at the end, we see this instrument, we see TRIPS, and we see this non-discrimination principle. And then we see the non-discrimination principle saying, not as to field of technology, no discrimination as to process or product. All products or all patents, all patentable inventions have to have a specific term. And it's no coincidence that these are the same things that the pharmaceutical industry was concerned about. So where do I come out then? I don't come out with the less restrictive approach. I don't come out with the most restrictive approach. What I say is that there might be a middle ground. It might be so that as to most inventions, we can differentiate. We can provide different treatment for those inventions. If there's one that we can't, though, it seems to me it has to be pharmaceuticals. And I'm with many in the group who feel that this is unsatisfying. It's not a favorable decision for me because pharmaceuticals are so important. They're so vital to the interests of varying states that we want them to have the ability to differentiate or discriminate as to these. But I just can't read it from the history. And so the idea that if we have a justifiable reason, that sounds true, that rings true, but I would ask then, those states who were prior to TRIPS discriminating or differentiating as to pharmaceuticals, what were they doing? Why were they doing so? On what grounds? It seems to me that a strong argument would be made that they were doing so for justifiable reasons, for bona fide reasons. And yet, if the pharmaceutical industry was pushing to change that, and then we make an end run around it and say, but that's really how we should interpret this, it seems to me that the pharmaceutical industry did not get anything, or at least not as much as they thought they were getting in TRIPS. And I find that hard to believe in light of what I've read, what I've heard about the origin of TRIPS. So if that's the case, if that's how we should read this, that differentiation has its limits and its limits go up unto the pharmaceutical industry, then I think that the blanket statement in the Declaration that the terms are different, and because the terms are different, states have unfettered discretion to limit or to treat different inventions differently. I think that we need to look at that again. There's another part of the Declaration that I have some quarrel with, and that's the idea of the limitations and exceptions. We had talked about this in connection with copyrights. But it's also the same thing with patents. So Article 30 provides the limitations and exceptions for TRIPS. Members may provide limited exceptions to the exclusive rights, provided such exceptions do not unreasonably conflict with the normal exploitation and do not unreasonably prejudice the legitimate interests of the patent owners. This is commonly referred to as a three-step test, and because it has three separate steps, must be limited, cannot unreasonably conflict, cannot unreasonably prejudice interests. The interpretation that's advanced in the Declaration is that these three steps are three factors that we can then analyze and come to an ultimate conclusion as to whether limitations or exceptions are then valid under TRIPS. That is one interpretation. I think, though, that we at least have a WTO case that has ruled on this and has said that that's not how we should view these limitation and exceptions. Rather, we should think of them as cumulative. Each one needs to be met, and if one is not met, then we don't have a valid exception. Now, I know that there are plenty of people who take exception with the WTO decision. I think Rochelle referred to it today as mangled, a mangled interpretation. And my complaint is not so much with whether the interpretation is right or wrong. My complaint is more that if it is wrong, we simply can't ignore it. We simply can't disregard it. It is a WTO decision. And despite the thought that WTO decisions are not binding precedent and they're not followed, I think that they are in fact followed by many people. They're certainly followed by WTO jurists, countries, not only the countries that are party to the dispute, but also other countries follow WTO jurisprudence. And so I think ignoring it has some significant consequences. Beyond that, it's not as if the WTO has only looked at this issue one time. We saw them look at this in Canada Pharmaceuticals, where they said 3 factors, cumulative. They came back again in United States Section 110, looking in this case at copyright limitations and exceptions, not patent limitation exceptions, but the wording, the structure, the text, virtually identical. And there again, they said, yes, it's a 3-part test. Yes, it is cumulative. 5 years later, they came back and looked at the limitations and exceptions for trademarks. Again, similar structure, similar language. And again, they said, 3-part test. Not only is it a 3-part test, it is cumulative. And so I think it's one thing to say that they got it wrong one time. I think it's another thing to say they got it wrong twice. Now we're saying they got it wrong 3 different times. And that might be the case. Again, it might be the case that they got it wrong. But if they got it wrong, then what this probably suggests is that WTO law is important. It is binding. It is precedent. And so if they got it wrong then, well, they're still going to look to it again. And they're still going to look to it again. So either way, it's either they got it right, they had a number of opportunities to look at it, and this is how it should be, or we need to pay attention to WTO jurisprudence, and we can't simply disregard it. If we want to overrule it, we need to do so in a different way. We can't do so by simply placing in a declaration, this is how it should be. Okay. Obstacles in trying to overcome this decision. One, as I just mentioned, we have a de facto stare decisis system, even though it's often repeated, and I think technically true, that it's not stare decisis and it's not binding precedent. In fact, what happens is countries, jurists, follow WTO law. The second criticism is that if we do so, it might amount to judicial activism. And so there's lack of democratic accountability then. There might be some legitimacy issues. And so again, we simply can't overrule it or disregard it. We need to do something else to change it. This last point I have, inadvertently strengthening contested interpretation. What I mean by this is that what might happen is that the WTO gets an opportunity to look at this, and they rule in a way that's contrary to what we think is consistent with law. They get another opportunity to do so, and then they even more forcefully say, no, this is it. We bring it to them again, and they get another opportunity, and at that point it becomes entrenched. We see this with another issue. It's called zeroing, and it relates to the anti-dumping provisions in TRIPS, the WTO. And there, a number of countries were doing this practice of zeroing. It goes to a certain methodology in determining how much dumping is going on in a particular country, how much another country is flooding the country with cheap or inexpensive goods. And the WTO appellate body said, no, this zeroing policy is not good. Countries went back, and they changed the policy slightly, still following a zeroing methodology. AB came back, the appellate body came back and said, we said this wasn't good. Countries changed again, came back again with another zeroing policy, and the AB said, zeroing is impermissible under the WTO agreements. Okay. And that's the fear here, that we're going to get this strengthening of this position that's against the position that we're looking for. Okay. So some of the potential consequences going to threaten legitimacy of the WTO as an institution because we are not following institutional practices. And also this idea of rule of law that has now run through the WTO. We're going to be flouting the rule of law, and I think that there are some normative and institutional consequences of doing so. So what can we do, if anything? And this is where I look to, are you giving me a sign? Sorry. Okay, sorry about that. So this is where I look to things that have happened in the international community, particularly in the international intellectual property community, as ways to change law. We have seen dramatic changes in these dynamics of international lawmaking. We see it with issue creation. So here what I'm referring to is creating an issue that then gets transported or transplanted into an international regime. We saw this with services. Services prior to having trade and services linked, so that now becomes a trade issue, services were discrete issues governed by national regulatory bodies. But then this idea came that maybe that there's some kind of commonality with services. Maybe there's something with insurance, something with banking, something with finance, something with haircuts, something with all these services that we can group them together. And that idea was trade. Let's link trade and service together. We create this issue. Now we place it in an institution that governs trade. Regime shifting. This is simply changing the form in which we now have to look at a particular issue. So the idea is we are dissatisfied with the norms or the rules in one institution. We go to another institution that's more favorable, perhaps creating some soft law here. You're doing something here that then has some impact on the laws in the initial or the target institution. We saw this, for example, when we moved from WIPO to the WTO. Intellectual property was in WIPO single institution or single issue institution, only intellectual property. And then because developed countries were becoming dissatisfied with WIPO and the perception that they are more favorable to developing countries, they shifted to the WTO, where they now had a framework that had an effective dispute mechanism, dispute settlement mechanism. Also, it was a form that was more favorable to large trading countries. And so we see this shift, this regime shift, again, new way of making international law. Competitive regime creation, something similar here. And by that I mean trying to change laws or rules in one regime, and this time rather than going to another regime by creating a competing regime. So the example that I have here, the Global Alliance on Vaccines and Initiatives, the target regime was World Health Organization. And the issue was vaccines for children in developing countries. Those actors who are dissatisfied with what was going on in the WHO created a new institution, created something that would compete with them, and then challenged their dominance, there being the WHO, challenged their dominance in developing vaccines for children. Okay. And then finally, I want to point to grassroots movements. And here we see actors, particularly NGOs, non-state actors, who then agitate for change in, again, a target regime. We've seen this in, for example, with Doha. We've seen this again recently with the Marrakesh Treaty for the Blind. And all of these, I think, are examples where we can see some kind of change, or at least efforts to change an inconsistent and unfavorable a decision or a rule or law that we are dissatisfied with. Okay. Let me conclude here with some things that we might want to look to. In all of these areas, those who are responsible for change identified some key characteristics of what made them successful. One is this, what I referred to as a national phase, creating a community of experts. Now, I think Rito earlier and Fred were discussing whether academics can have any kind of influence. And I think I agree with both of them, with Rito saying, you know, if it's just academics speaking to academics, might not get very far. But if we're talking about academics who have ties to top policymakers, who also have ties to industry, then that's where you start seeing change. And so in these areas that I pointed to, those who are responsible for change said, this is what we need. We need a community of experts, but it's not just one set of experts. It's a two-tier system. And in one tier, we have personnel from the government, from international agencies, from government international agencies, and from private parties. In the other tier, we have academics, we have journalists, we have people who can lend credibility and also insight to those others, and then this community then gets to present the change that we seek. Then there's an international phase where the community reaches out to others internationally, to like-minded people, so that we can start having this consciousness raising. That's how we're going to effectuate change. It's not going to be done in any one institution. It's not going to be done in any one group. It has to be something where we see this global push for it. And so the success stories that I point to, Doha and the Marrakesh Treaty for the Blind, these are examples where we see some of this in action, where we see something from the grassroots level, where we see non-state actors having an input, and we see, more importantly, we see change. In one case, we see change to pharmaceuticals, something that was extremely contentious, which most people did not think we'd get any change, and yes, we saw we got change. The second one, the Marrakesh Treaty for the Blind, we have change, and we have change with respect to limitations and exceptions. Limitations and exceptions to copyright there, but again, another area that seemed intractable, that seemed as if it was not going to be going anywhere, and we see change again. So the last thing I want to point to is something that one of the Indian delegates to the TRIPS negotiation is talking about, and she talked about it in connection both with the TRIPS negotiation, and then later on, 6 years later, with the Doha Declaration and the Doha negotiations. And what she said is, as I look back, I can see what the differences were. The developed countries came with a plan. They came with a unified front. They had specific demands. And at the time, TRIPS, developing countries as a group, they were not unified. They did not come with any specific demands. And there was no public support. The public support was garnered by the developed countries who framed intellectual property or theft of intellectual property as piracy, as counterfeiting. And so the developed countries were on the defensive from a public policy standpoint. 6 years later, in Doha, things changed. Developed countries came with a plan. They came with a detailed proposal. They were unified. They also garnered public support by raising consciousness about the Access to Medicines campaign and the Access to Medicines issue. And so we see a drastically different result there. And so I want to close by saying this. It's not with the underlying goals of the Declaration that I have a problem with. I think, though, that in order to have some certainty, in order to have some credibility, in order to have some real change, we need to look at other ways to do it other than through these reinterpretations or these pronouncements in the Declaration that I think are hard to reconcile with current law. I was really pleased to hear Rito at the beginning of his talk about what they're trying to do with the Declaration, because as I read it and as I thought about it, I was thinking this is the component that's missing. But he described earlier how they're going from country to country, how they're introducing it. And I think that's wonderful. I think that that's what needs to be done. The only thing that I would tweak is the actual content of the Declaration. Okay. Thank you.
Would you like a microphone?
No,
Oh, that's fine.
as long as. That's right. it's working. Well, thank you, Dan, and to the university and the law school as well for the invitation to be here today. And of course, it's a pleasure to see all the familiar colleagues and guests as well. My presentation today takes a little bit of a different track. It's not so much about the declaration itself as something that might be called something that interstitially falls within the scope of the declaration, but perhaps a little bit more to another side of the Max Planck Institute, to the extent it's concerned with competition law, and even going back to Wolfgang Fickenscher's work on international competition law principles. And the subject of this discussion flows out of work I've been doing for several years now with the United Nations Development Program, in which the objective is to both promote and provide frameworks for developing countries to use competition law more effectively to promote access to medicines and lower priced medicines. But I think what you'll see in today's program is that the issues I'm talking about really are of equal relevance to the United States today, and in fact, a lot of the issues that I'm talking about are things that are presently just before the Congress and involve issues recently decided by both the U.S. Supreme Court and the California Supreme Court in a very important case, Cipro 1 and 2. The basic ideas, just 30-second encapsulation. Number one, as is fairly well known, there is a good deal of flexibility at the multilateral level in terms of the application of competition law, and this can serve as a substantial counterweight to overprotection of patents and related intellectual property rights. We see that developing countries, especially emerging market countries, are becoming very much more active in the implementation and enforcement of competition law. So, for example, whether it's China, Brazil, South Africa, Russia, India, you all have a lot of activity at the competition law level, competition commission level, to the extent that, well, for example, we'll talk about momentarily, the U.S. Chamber of Commerce is becoming increasingly agitated about the application of competition law. What I'm going to be talking about today primarily is the development of doctrines in competition law that have not been actively developed in U.S. law or even in EU law, but which I think are important both for the industrialized countries as well as the developing countries to develop. These primarily relate to doctrines involving excessive pricing and essential facilities, and that as a consequence of this current practice and what I foresee as an evolution, I think we may see kind of a paradigm shift in the attitude of the multinational business community about whether or not we should in fact have multilateral rules on IP, which may be one of the consequences of more active application. So in case you've been sleeping in an ice cave in the Arctic for 50 years or so and may have missed it, we have a fairly well-known and well-documented story to highlight that competition law is weakly regulated at the multilateral level, right? This goes all the way back to the negotiations for the Havana Charter for an international trade organization, followed by negotiations in UNCTAD. You had competition law at the encouragement of the European Union, was put on the Singapore agenda. You had the formation of the WTO working group on competition law, none of which progressed very far. And the reason for that not progressing very far was kind of a twofold pushback, both led by the United States. One was the U.S. multinational business community, which didn't want to see itself subjected to multilateral IP disciplines. And at the same time, you had the U.S. Department of Justice and Federal Trade Commission, which didn't want to see itself hamstrung by multilateral rules. So the United States pushed back against the European Union effort and agenda in the WTO, and was also joined by developing countries in that effort, which were particularly concerned with some of their programs falling afoul of potentially national treatment issues if there were ultimately an agreement. I think we're all familiar with the basic parameters of the TRIPS agreement, and it's to the extent it regulates competition. You have Article 7 and 8, Article 40, Article 31K, Article 6 on exhaustion, various other articles, directly or indirectly discuss intellectual property and its relation to competition, but really in a very weak way. There's very little in the sense of firm rulemaking in the TRIPS agreement. I think the only rule that might actually end up having a little bit of bite, which hasn't been given much attention, is the national treatment rule. I'm not going to discuss that now too much. But so at the very heart of what I'm talking about is something of a shift in the way we think about antitrust or competition law, which actually goes back to the origins of antitrust law in the United States in the late 1800s and the early 1900s, how antitrust law developed, and I make specific reference here to the seminal case of the Supreme Court in Standard Oil of New Jersey v. the United States, where if you look at the early Supreme Court decisions, the focus of these decisions was on protection of the consumer, was that the trusts were abusing the consumer and leading to excessive monopoly prices, and that the role of antitrust law was to protect the consumer against this abuse, what today we'd call abuse of dominant position or monopoly. In the late 1980s and early 1990s, under the heavy influence of the Chicago Economic School, you saw a real shift in the focus of antitrust law in the United States towards a producer-side analytic approach, which basically took the position as long as you've got competition among producers, you're going to have market efficiency. That's going to lead to lower prices. Everyone will be protected. So you don't really need to focus, as it were, from the target, that is the consumer. You could focus on the producer, and the benefits would naturally flow to the target. But I think that presents certain problems because a number of the adverse effects of what I'll refer to as anti-competitive practices in the public health sector do not so much involve abuse of dominant position in the context of a producer-to-producer relationship or even a producer-to-distributor relationship, but in reality involve a bilateral relationship between the dominant producer and the consumer. And I'll explain that a bit more. And as a consequence of these things, I'm suggesting a shift in focus back to the original conception of the Supreme Court in the early 1900s to protection of the consumer, and shifting focus a bit away from the producer-to-producer context. And in that regard, one of the things I think we need to do as a kind of the competition law community is elaborate better doctrines relating to excessive pricing and essential facilities, which are doctrines that really are not, there is hardly a doctrine of excessive pricing in the United States in the context of which I'm talking, very limited, almost nil attention to essential facilities in the United States. You do have a bit of elaboration of an essential facilities doctrine in the European Union, but it's a very, I would call it a narrow conception of essential facilities, and I think more work needs to be done in that area. So basically, again, and I realize I'm reiterating a point here, shifting the focus to defining market dominance in terms of the control over the welfare of individual consumers and or we can say purchasing groups. So if you're talking about a particular cancer drug that's good for treating a very narrow class of patients, and you're talking about excessive pricing. You can talk about that bilateral relationship either in terms of an individual, or you can talk about it in terms of a community health plan or the purchasing agency that's involved in this. And therefore, you're talking about market dominance, not in terms of dominance over an alternative group of producers, but market dominance in terms of the individual consumer in a bilateral relationship. And I'll make this simple point that a consumer with a life-threatening disease and for whom a single therapy is the only effective treatment, you have an inelastic demand curve that is up until the point the person is dead. They will pay any price for access to the drug that the producer wants to charge. So I would call that a position of dominance vis-a-vis the individual consumer. So now most of what I'm going to talk about now, and I realize this is probably excessively boring, is methodological, because part of the problem, and I have to say I've kind of gotten to this point with this that, for lack of a better way of putting it, I'm tired of people telling me that this can't be done, right? That the reason we can't have an excessive pricing doctrine is because we don't know what a reasonable price is or what a normal price is for a pharmaceutical. And if you don't have a normal price, you can't determine what is an excessive price. And of course, the pharmaceutical industry takes the position that you just can't put a price on this. We can't tell you how much it costs to develop a drug. It's highly indeterminate, and so there's no point in even asking us. The latest way they're approaching it is let's forget all this worry about how much it cost us to develop this drug. Instead, we think you should pay us the value of the drug to society. And what's the value of the drug to society? The value of the drug to society is how much it would cost us if we hospitalized you for the next 16 years and cleansed your kidneys every third day with teams of doctors. So the alternative cost to our pharmaceutical may be millions of dollars of treatment. Therefore, you should pay us millions of dollars for our drug, even though it might cost us $115 to manufacture, because the alternative is that we check you into the hospital for the long term. To my mind, this kind of value for money analysis that's currently being used, well, of course, the intent of the industry is to shift focus from how much did this cost us to develop to how much can we possibly charge you for it. But it shows the power of the bilateral dominance, right? How could you charge that much? Well, we can charge that much because we're in a dominant position and you don't have an alternative, right? So then the question does, how do you calculate a reasonable price? Well, is that truly an insoluble problem? Well, so I would say the preferred methodology for telling us what the appropriate price is to determine what the cost plus a reasonable profit is adjusted for risk. Now we'll get back to this adjusted for risk question because this is where the complexity comes in. How do you adjust the cost for risk? But there are a variety of other approaches that really governments, including the Australian government and the Canadian government, lots of other OECD countries use for determining or assessing prices. So these include reference pricing, and you're all familiar with that, right? Reference pricing, you look at the price of a basket of drugs in 12 countries and you take the average selling cost, or you take the lowest selling cost and so forth, and you determine what your price should be by reference to other prices. The problem I have with reference pricing is that it's this extraordinary circular process. I mean, you determine the price by looking at other people's prices and then you know what the price is, and I find that kind of unsatisfactory. Peter Draho suggested to me that the way the Australian Competition Authority tries to look at it is by seeing what the price result is between a monopoly supplier and a monopsony purchaser. So if you can get kind of absolute bargaining position on both sides of the equation, you may end up with what an ordinary value would be. Of course, you can get pharmaceutical companies establish the price of drugs all the time. I mean, they do it when they acquire target companies, right? I mean, that's how originator companies ordinarily develop new drugs, is they look around the world for who's got a promising candidate, and then they pay them an amount of money. I mean, they're paying the amount of money on an assessment of how much did it reasonably cost them to develop that drug, and therefore to reduce our risk, and we're establishing a price. So, for example, in the famous case of Sovaldi, right, this was Gilead paying $11 billion for a company called Pharmasset, which had developed the drug, and then somewhere between doubling and tripling the price that Pharmasset had intended to charge for the drug on the grounds that they paid a lot of money for. Gilead's rationale was, well, we paid a lot of money for them, therefore we had to raise the price. And you've got these things going on today, and why Valiant is going before Congress and so forth. You have, of course, drug companies do report their costs to tax authorities. Okay? But it's not clear that they provide the costs in a way that you can break them down sufficiently for individual drugs. So to a certain extent, this presents a problem. And the drug companies report their R&D costs to the Securities and Exchange Commission. They usually report them as aggregate figures, but it does lead us to believe they actually are keeping a record of what their costs are. So that leads to the big question in this area. So the main argument for we can't tell you how much it costs is, well, because there's a lot of risk involved. And if you can't quantify risk, you can't quantify price, right? So how can you tell me what the price is if you can't tell me what my risks are? And of course, then you can get into dividing drugs into, you can look at risk from the standpoint of how many are unknowns in a process, right? I mean, for example, in drug development, there are certain low-risk drug development research ventures that go on. Sometimes we refer to them as Me Too drugs, but when you're taking a drug and tweaking a molecule to provide a certain more beneficial result, but you have a pretty good idea you can do it because the science is pretty well known, you're in a fairly low-risk environment, and I think it's not so difficult to quantify the risk in that context. Then you have other areas where you have, let's say, the highest risk. The highest risk is where you know neither the mechanism of the disease nor the mechanism of action for the drug that's going to approach the disease. So you can have kind of large number of unknowns on both sides of the drug development equation. And the way we try to take that amount of unknowns out of the equation is the NIH funds research into kind of the basic mechanisms of the disease, if not the mechanisms of action of the treatment, although really both. So we already do have a lot of programs in place to reduce the initial risk of development, which then translated already into a patented technology which the company is acquiring with the risk already having been at least substantially or very substantially assumed by NIH research. The level of risk can depend on the nature of the company. Is it a single-focus company or a multi-focus company? So you can have a company like Novartis, which may be, working on development of 100 drugs at the same time, or you can have a small biotech company which is literally working on one drug. So if you're literally working on one drug, you're probably in a very high-risk environment, because if that drug fails, your whole company fails and there's nowhere to go. If you're developing 100 drug candidates, well, then maybe 3 of them will succeed, but not one of them threatens the security of the enterprise. So you have different profiles depending on how you're doing that. Now, once you get into the type of institution, then you also get into cost accounting questions. So if you look at the originator pharmaceutical company, although they do vary their research structure along different lines, they're generally dividing their research into either classes of chemicals or biologics, and or classifying their research into therapeutic targets. It can sometimes be both, but you do have breakdowns of parts of the business that are researching in particular areas. So if you want to do a cost accounting, you can approach it. Let's say you were wanting to say, okay, well, we'll give you all of the risk you undertook in doing this research on Alzheimer's. We'll look at your whole Alzheimer's department, right? But we're not going to look at your cancer department and your liver disease department and this other biotech department here, all as part of your cost accounting structure. And so you can do cost accounting functions that take into account risk more broadly. And then another thing you can do is exclude certain costs, right? So you exclude the basic research costs from the government. You exclude executive salaries above a limit. So, when Hank McKinnell left Pfizer, after having tanking the entire company, they gave him $80 million going away bonus because he'd done such a wonderful job. You do have these very high salaries for pharmaceutical company executives. The companies may want to pay them, but I don't think we need to reimburse them for them. Another neat trick of the pharmaceutical industry is the opportunity cost of money. We're going to charge you 6% of our capital costs because we could have taken that money and invested it in high-risk bonds and gotten a 6% return. And since instead we didn't use that money to invest in bonds, but instead we invested it in drug development, we should be able to charge you for that 6% that we could have gotten if we had actually been investing the money in drug development, which is a curious argument because they're actually getting the money from the public, which is the equity investor in the companies. So I don't know why you would be paying them an opportunity cost of money. And then tax incentives, right? So there's R&D tax incentives that go into that. And when you get through with all that, I do think, and this is a work in progress, right, that we can go a long way to quantifying what the reasonable costs of developing a particular drug are. And if we can, on a risk-adjusted basis, determine what the reasonable development costs of a drug are, then the next step in analysis from an excessive pricing standpoint, of course, is then saying, well, now we've established a baseline. And if we've established a baseline, what is in excess of the baseline, right? What is a reasonable profit and what is excess? Well, so one thing is, well, we could just, you can compare norms of profitability. You can say a reasonable profit is a profit either from people in this industry above their R&D and production costs. And I guess here I want to take a step backward. Production costs are pretty easy to figure out, right? That's standard cost accounting. Now, it happens that historically, originator companies have been inefficient producers because they make so much money from the patent premium that they haven't paid much attention to efficient production costs. But they are changing in that regard because the industry has been under pressure, so they've actually been cleaning up their production act. But we can determine what the actual costs are. We can look at other industries. I suspect that most of the cases we've currently got going on about excessive pricing are cases in which the prices are so much higher than we think they should be that it is not so hard to determine if we can find a baseline cost that additional cost is excessive or additional price is excessive. But we still may want to determine what the normal cost and an excessive price would be because ultimately we're going to have some remedy, and the remedy is going to be based on what the cost should have been or what the price should have been if it had been a reasonable price. And so I would just note it's quite interesting that today, and this is a fairly new development, we have the UK Competition Commission has just opened up an excessive pricing investigation under the competition law. We've got just in the past week, the U.S. Congress has started a couple of excessive pricing investigations. We've got New York Attorney General opening up an excessive pricing investigation. So we're actually starting to see people paying attention to excessive pricing and what is an excessive price. So part of my thesis here is that, and this isn't by any means only relating to the pharmaceutical industry. For example, in China, the cases haven't actually involved the pharmaceutical industry. They've involved the electronics industry and the router industries and so forth, and software industries where the Chinese competition authorities have taken aggressive steps, which is an interesting, thing. And if you read the U.S. Chamber of Commerce report on, application of competition law in China and its critique, you'll see the problem I'm talking about is that they have a lot of difficulty identifying what the baseline rule is, right? Well, the Chinese shouldn't be doing this. We're not exactly sure how to tell you what they're doing that isn't right because we don't really have rules about this, but we know this isn't right, and here's what we think they should be doing. And I'm not suggesting that the Chinese aren't doing anything wrong. I'm just saying that the problem the industry confronts is, in the absence of a baseline set of rules, it becomes difficult to say, here's what you're doing that's not right because, what's wrong? I suppose as an anecdotal humorous aside, one thing that I did find interesting was the complaint in the Chamber of Commerce report that, well, Chinese authorities appear unannounced at the doors of the companies and, hold employees aside while they search the premises, and that this was, clearly a violation of human rights or dignity or whatever. And yet, that's precisely what the European Competition Commission does and the Department of Justice does. If they have reasonable grounds to believe there's an antitrust violation, they don't send you a notice saying, we're coming to seize your computers next Tuesday. They show up at the door with a bunch of armed guards and tell you, please sit at your desk while we take your computers out of the office. So all of this isn't done with kid gloves. And my guess is, though, and this is just a guess, that as the multinational business industry begins to perceive that the risks of being subjected to antitrust actions or competition law actions exceeds the benefits that they have from not having rules, that is, not being subjected to these rules, that there may be a certain attitudinal shift that says now we need to shift and have multilateral rules so that we aren't arbitrarily subjected to rules that we don't find favorable. And this goes back then to the kind of the theme of the Max Planck Declaration, that I think that developing countries should be very wary of surrendering their flexibilities under competition law. Instead, that they should be looking to develop doctrines, again, in the one size doesn't necessarily fit all approach, that different countries will have different reasons for following one approach versus the other. And we see this going on, that developing country competition authorities should promote cooperation and investigative capacity, doctrinal development, enforcement capacity, and so forth as an alternative. And, there are groups, even kind of quasi-OECD type groups like the International Competition Network, which do a good job on baseline competition rules, even kind of outside the context of just the developing country approach. So I apologize, that's a little dry, but that's what I'm working on, and dry stuff is dry stuff. Okay, thank you very much.
Okay, you to join us. Again, my thanks to both panelists, not only for the excellent content, but also for the rigor, keeping track of their time. So we've got at least 20, maybe 25 minutes for discussion and questions. I think Rochelle, hand was up first, so we'll start with Rochelle Dreyfus.
Thanks. So, Donald, I'm really shocked by your argument about stare decisis. There's no stare decisis in the WTO, not just by happenstance, but because there are actually good reasons for it. So think about the three cases you want to apply stare decisis on. One was the EU.
I'm gonna mic you here, so.
So I'm asking about stare decisis, and I'm a little shocked that you want to apply stare decisis. Think of the three cases. So the EU sues the US, the EU sues Canada, and the EU sues the US, or the US, yeah. And the US sues the EU, right. So all of these are cases between completely developed countries. All of these countries want to keep to a minimum the limitations and exceptions because that helps them in other cases. They're not the investors, they are the countries. So the countries care about their own law. And the idea that the law is going to develop among developed countries because they are the ones who happen to be able to finance WTO dispute resolution, or they're paid by Philip Morris to finance WTO dispute resolution, is not a very good argument for saying that stare decisis applies. In normal judicial cases, there are many litigants on any one issue, and these cases pile up, and after a while we have an understanding of what the norm is. That doesn't happen here. We have all the 7 cases, and we don't have any more than that. So for that reason. Also, this is a really embryonic system. We need some accumulation of information before a norm develops. And the idea that whatever the first panel says, based on a bunch of cases about trade in goods, should apply to IP when they have never, ever adjudicated an IP case before, is another reason to wonder about stare decisis. And then there's this is just a small issue, the other is what I think of as the big issue. The small issue, the EU GI case actually is different. And you see some movement in the EU GI case. And you see, first of all, what they call 2 factors, not 3. They think of taking account of the interests of the right holders and third parties as a little bit different from the 3rd step. You know, they're not quite saying we're backtracking, but there's a little bit of backpedaling going on in that case. And rightly so, because they looked at the first 2, because people like Rado had the declaration on copyright, and lots of other people said the cumulative nature of these tests makes 0 sense. The United States, hard to believe the United States thought this way, this would be interpreted this way, given the way that we interpret fair use, confusion in trademark cases. We don't have cumulative tests. Really hard to believe the United States even thought that's what we were getting. And so, you know, for all of these reasons, it just seems hard for me to understand why you would ever want to say in the first, I don't know, 20, 50 years of TRIPS agreement that stare decisis is a value at all.
Great. Thank you. Let me say this, though. I wasn't suggesting that that's what I want or that's how the system should be. In fact, what I was suggesting is that looking at these opinions, looking at WTO opinions, that is in fact what it looks like is happening. Not that we should have that, but you see you read any opinion, they're referring to other opinions, and they're relying on these other opinions. They're relying on them not simply as persuasive, but when they have the same issues, they're relying on them as binding, or at least almost as binding precedent. And so my argument is not that this is the system that it should be. I absolutely agree with you. I think that because we have no developing countries in the WTO dispute settlement for the first 15, 20 years, that all of the rules are going to reflect developed country interests and views. And so we shouldn't do that, but I think my point is, it looks like that's what's going on, and so if that's not what we want, then we need to do something about it.
But it goes on that way because the EU and the US and Canada set these arguments up the same way every time. I don't know why we need to tell developing countries this is the right rule, because because when they come to the WTO, they won't set the case up the same way. And, you know, one other thing is the pharmaceutical case and the 110.5 case were decided practically simultaneously.
Right.
I think it's
Right.
really strange to say that one was based on the other.
I think it's true that they were decided months apart. But we have another case, and I appreciate that the distinctions that you're making with the EU trademark and geographical indications case, but I think that you could read it as being consistent with the first two. And we're not talking about a matter of months there, we're talking about a 5-year period there.
So I have a related but somewhat different point than Rochelle, which is, I guess I don't see the Declaration as flouting the rule of law. I see it as offering insight. So just like we have opinions in the US and then we have statements, ALI, et cetera, those can all be helpful, informed views of experts. And I also don't think necessarily that the older cases you cited would necessarily come out the same way, even without regard to this declaration, because something really important has happened since then, and that's, we have the Doha Declaration, right? So I view this as sort of equivalent to the Doha Declaration. Obviously it doesn't have the same weight in that it's not from member states, but I don't see why we can't have these other things supplement and inform without saying that we're completely disrupting the entire system.
I think there, and I spoke with Rita about this because it wasn't clear to me what the Declaration was trying to do or how the Declaration should be read. And so I initially read the Declaration as this is a law, this is international intellectual property law. And that's where I had an argument with. Not that it should be this, we recognize that it might be something else, or there are different interpretations, but rather this is what international IP law is. And so when he explained earlier that the whole goal is not to say to developing countries or to whomever may use it that this is the law, but rather this is a reinterpretation. I think I'm much more comfortable with that. And so I agree with you that certainly if there is something that we want to change, or if there are reasonable different interpretations, that certainly we should have healthy debates about what should be or should be the right interpretation. As to the Doha Declaration, I guess I view that slightly differently because I think that one view would be we don't need the Doha Declaration if we're just going to reinterpret what TRIPS provides, but we need the Doha Declaration because we are changing some of the rules. We are changing existing rules. Certainly 31F we're changing. And so that, in fact, would be an example of saying yes, leading to healthy debate to change the rules, not to simply reinterpret the rules.
So there's several hands, but I'm going to selfishly inject myself as the moderator because I want my question to get answered too, which is for Fred. I mean, you start out by indicating, of course, that TRIPS doesn't say very much, except maybe by implication, about how competition law sort of fits into the intellectual property scheme. And so the question that kept running through my mind is, as you were kind of mapping out your argument, is really pretty basic. To what extent can you use an argument like this, whether it's for essential facilities or for excessive pricing, to inject a flexibility where many people wouldn't see one, or to be a little more pejorative, to what extent can you use competition law making end run around something like, let's say, the prohibition on, that Don was talking about, treating different technologies differently, right? If you have a whole bunch of decisions or actions in a particular country that say, you know, well, this pharmaceutical is essential, this pharmaceutical is essential, this pharmaceutical is excessively priced, can someone then push back and say, well, you know, you keep doing this for pharmaceuticals, you never do it in software, so I think you're treating technologies differently. Is that, at what point does that become a problem?
Well, I'll take those a little bit two different observations that you're making. The first one is to paraphrase Richard Nixon, to say that we would be doing an end run about the TRIPS agreement, around the TRIPS agreement, would be wrong. But to the extent that we're saying that there is a flexibility available to control the application of intellectual property law, I think would be correct. And I think that as we are finding in the United States, and I would refer you to FTC v. Activists and CIPRA 1 and 2, where we now have the Supreme Court saying that, you know, patents and antitrust law are complementary, and that, you know, one can be applied vis-a-vis the other, signals to us that there's a lot of flexibility for controlling patent excesses through the application of competition, which is not controlled by the TRIPS agreement. And many of the excesses that we think about when we talk about why do we need to have a rule in the TRIPS agreement to provide an exception for X are things we can get at through the application of competition law. Now, as everyone in the room knows, that isn't always easy, because competition law proceedings can be, you know, time-consuming and expensive, which then goes to the question of developing per se rules or quick look rules versus rule of reason tests and so forth. I think then part of this goes to doctrinal development. The reason we want to develop doctrine is because we want a better baseline of knowing what we're doing, right? So we develop the doctrines and then we can apply them. Each case doesn't become developing the doctrine so that we can apply it, but we've got developed doctrines. But I do think that these are very important avenues, number one. Then, you know, you make a point which is, well, but if you're only applying it to excessive pricing of pharmaceuticals, isn't that going to signal some kind of differential or discriminatory treatment? Well, one thing I'd start by saying is that in other fields, if we look at, you know, smartphones and you know, other kind of electronic technology devices, we have very few instances where companies wake up one morning and decide they're going to charge 500% of the price of the prior price because they can. And the reason they can't is the markets tend to be more competitive, right? And smartphone technologies, with dear apologies to everybody who's an Apple fan, I mean, most of these technologies are really just very incremental, and, you know, today's smartphone and yesterday's smartphone really aren't all that dramatically different. But so you don't have the kind of abuses where you're saying to someone, well, you've got cancer, we've got a drug, we're going to charge you $300,000 a year because we can. Maybe you can't afford it personally, but your health care plan does. And if, you know, and so it may be that at least in the current environment, the place we have these abuses is in the pharmaceutical sector. But as I said, I mean, these cases are coming up in all kinds of different contexts. Electronics, you know, computer software, standards, and so forth.
So it's not discrimination as to technology, it's discrimination as to markets, right?
Discrimination as to market, very well put, and, you know, and to what extent certain behaviors tend to be endemic to certain industries.
Marquetta Trimble has some.
Also a question for Professor Abbott, and also about discriminating among the markets. My question goes to finding the reasonable price.
Mm-hmm.
And the question is, if a company actually operates at a global level, right, so it has markets in multiple countries, how can that be accounted for in the reasonable price for a single country like the United States? And would it make any difference whether the United States keeps or adopts the principle of national exhaustion of patents as opposed to international exhaustion of patents? Would that make any difference in considering the foreign markets when calculating reasonable price for the United States?
Mm-hmm. Well, my immediate reaction to your first question is that if we are determining a reasonable price on a cost risk-adjusted basis plus a reasonable profit, that the market doesn't really matter. it might matter in the context of what is a reasonable profit. So a reasonable profit in the United States could be 50%, and a reasonable profit in India could be 3%. I mean, you could, but, you know, my belief is that in most contexts, if you could actually identify the real price, that the prices you're being charged are far different than the real cost of development, and therefore, while that is an issue, I don't see that as kind of a fundamental issue in this area, and that also in part also addresses the exhaustion question, that if prices were more reasonable, you'd actually probably have less arbitrage issues involved with, you know, exhaustion and national versus international exhaustion. But again, I don't want to suggest that I don't see circumstances in which discriminatory pricing provides a value. For those without historical memory in this area, and there are people in, you know, in that context here, you know, these arguments were first made by the originator industry in the early 90s and the mid 90s, which was, well, you have to allow us to price discriminate because, you know, we want to provide low-cost drugs to Africa, and we can't do that if you don't let us provide. So then you went and looked in Africa. Well, where are these low-priced drugs? And the fact was they weren't, right? That in fact the prices in Africa were higher than the prices in Switzerland because they were pricing to the wealthy markets and not to the, you know, low-income consumer markets. So the whole argument was basically at that time just made up. Okay, now. Today, we are in a somewhat different world, right, where companies are offering, like through the medicines patent pool, very low-cost licenses, and you get, you know, low-cost drugs available in developing country markets. Now, my view, and it goes a little bit to the answer I was giving to Rochelle before, was that if the operative purpose of what you're doing is allowing that discriminatory price in a particular case, like under an MPP license, that is an individuated case that you can address on a case-by-case basis, that you don't adopt a general principle of exhaustion to address that specific case, which can be addressed either or both on the export side or the import side, and doesn't really need to be addressed as a matter of patent law, can be addressed as a matter of export trade law. So, or even FDA regulatory law. I mean, there's lots of different ways you can get to control of pricing of drugs globally without, you know, saying, for this we need a national rule of exhaustion that applies to all industries. Which, by the way, is the implication of the oral argument. Some of the judges in the Federal Circuit was, well, you know, and God, I don't even want to use the literal language that they use because I find it so insulting, but which is that, you know, that we, the Court of Appeals for the Federal Circuit, are the sole bastion between chaos and, you know, protection, and therefore we're going to have national exhaustion. I personally don't buy that, but, you know, to each his own.
So we're coming up on our break. We might be able to fit in one very short question. It's quick and easy. Yes. Genevieve Humphrey.
How do countries that regulate drug prices or cap the prices that they will pay for drugs determine the drug price?
It varies quite widely. There's some big studies. For example, the OECD has, you know, has done a report on, you know, how prices are determined under price control systems and so forth. I would say that probably the most typical way it's done is through reference pricing, which, again, I mentioned, you know, is a circular way of determining what the best price is, because it's saying, well, we'll determine what the reasonable price is by looking at the price in other markets, but how did they determine the price in the other markets? So you're just kind of circling back to yourself to get a reference price. You know, there are countries with a lot of history with price control experience. The Chinese control prices. The Indians have a long history of price control, in which in the 50s and 60s, they did very detailed cost accounting studies, almost to the penny basis for how companies calculated their costs and, calculating a profit and what the price should ultimately be. And as I mentioned, I'm sorry, I don't mean to be going on, but as Peter Drahos had also mentioned, that the Australian competition authorities like to say, well, if we have a monopoly supplier and a monopsony purchaser, so we've got kind of bargaining power on both sides, where do they come out in the middle of that? But I would say the most common is reference pricing.
So we're up at our break time. For those who are viewing us remotely, we will be offline for the next 20 minutes. We'll come back at 3:10. For those who are physically here with us, there should be some coffee and other stimulants, I think, just around the corner. And as I mentioned, the men's and women's restrooms are out the door and down the hall to your right. And we'll see you back here at 3:10. Thanks.
Okay, welcome. I'm Fumi Arewa, and I'll be moderating panel number 4, Patent Sovereignty in a Changing Environment. We first have Cynthia Ho from Loyola Chicago, and she'll be talking to us about investor-state proceedings challenging internal IP norms. And that will be followed by Sean Flynn, who will be talking to us about the Declaration of Patent Protection and Regulatory Sovereignty under TRIPS and TPP. So I think it will be a very interesting panel. Thank you.
Hi, everyone. Thanks for having me. Special thanks to UC Irvine and Dan for inviting me. And super special thanks to Dan for making sure I can satisfy my Diet Coke fixation on a Pepsi campus.
We're supposed to say that.
Sorry. Okay, we'll just pretend that didn't happen. So I'm doing a different take on the Declaration, but yet different than what Fred did. So my topic isn't about just the Declaration, but how trying to do what the Declaration says we can do is going to be compromised by investor-state proceedings. So let's see, how does this work? I guess it goes like this. So I only have a current draft, but currently this is how the paper is set up in terms of there's a little background about what's IP and what is what's called investor-state dispute settlements, and how there's basically an unrecognized conflict among scholars, lawyers, and most of the public. And then after I lay out the background, I'm going to talk about what I think is a collision course that we're on. So there's 2 cases currently pending where I think we're going to have a conflict between the investment arena and TRIPS flexibilities. One involves Philip Morris suing Australia about its so-called plain packaging of tobacco, and the other is Eli Lilly suing Canada over 2 patents that were invalidated, which Rochelle alluded to earlier. I also think that there could be more problems down the pipeline, and I'll try to suggest some possible ways of addressing conflicts at the end. So I don't think we have to spend a lot of time on this, but intellectual property, we all know, used to be an issue totally of domestic flexibility before TRIPS. And TRIPS is a big deal in that it, for the first time, set out standards and said we do have to give patents. But as the Declaration we've been talking about all day says, those are supposed to be flexible because they're minimum standards that are not defined. So to me, that's kind of saying a dwelling could be any of these, igloo, teepee, house, they're all dwellings, right? So in the same way, you can say what's new or what's useful, it's whatever the country wants it to be. They were purposely undefined. Now, investor-state disputes are a whole different ballgame. Now, I know Rochelle mentioned this before, but I don't know that everybody knows what these are. So basically, the history of these is that they've been around a long time. They basically started in international agreements, mostly bilateral, right after World War II, when some brand new countries, or politically new, they wanted more foreign direct investment. But they didn't really have necessarily robust rules of law. So the way to get the companies to invest was to promise, well, if you invest, we will give you these brand new types of claims available only to you, foreign investors, not to our domestic investors. And that will make you feel better, and then you'll invest in us. It's a win-win. Before that time, what was happening was what some scholars called gunboat diplomacy, where investors didn't get what they wanted, and they went to their states, and the states couldn't agree, and then there were supposedly threats of war. I mean, this all precedes whenever any of us were around, so I'll just take them at their word. But it's really developed a lot. Now, I don't know if you can see this on the graph, but the graph shows you the number of investor-state disputes. So since 1995, they've skyrocketed. So before, they just kind of existed, but not a big deal. Actually, when WTO TRIPS was negotiated, there were international agreements promoting investment claims that provided these special rights, but they aren't really discussed at all, to my knowledge, at that time. So the different images here are to suggest some of the issues involved with these disputes. So as Rochelle mentioned, the people who decide these, they're not any particular jurisdiction. They're, just a panel of 3 usually commercial arbitrators. So there's this one image here with the black hoods. They're kind of different companies. That's one view of them. There's also the kangaroo with kind of beating down on the poor person. And what's really at stake is a lot of money. So unlike the WTO, when you're found in violation of TRIPS, for example, there's really generally no money unless you just refuse to do what they want and have lots of ability to pay unlimited money, as some countries obviously do. But generally, you just bring your laws into compliance. Investor-state disputes are totally different. Generally, the whole goal is to get money and lots of money. So the average award is over 16 million. Even if you win, average attorney costs are 5 million. That's a lot of money. Moreover, just the threat of a suit alone is enough to persuade some countries to change and drop their laws. So I didn't realize this until I was researching a paper recently on a related topic, but Australia is not the first one to suggest plain packaging. Canada actually thought about it earlier. And then the tobacco industry threatened them, and they're like, okay, I'm not going to do it. That was it. So we're talking Canada, major country, not poor developing country, plenty of resources, and they did an about-face. So there's been a lot of complaints about investor-state disputes in the recent past, including from people as diverse as Elizabeth Warren and the Cato Institute. They're not usually on the same page on things, but on this page, they both have issues. But what I find really interesting is that oftentimes those people who are criticizing still don't raise the conflict I'm going to talk about. Now, there's two kinds of claims at issue in these cases that I do want to spend a little bit of time on, which are called expropriation and fair and equitable treatment. So expropriation is a little bit like U.S. takings law, but it's generally much broader. So the general idea is, you can't take away the property of the company, including intellectual property. And there's two tests. One is the sole effect test, where all you look at is were their property rights diminished greatly. And the other test would include other factors. So you would consider, even if the company's property was taken away, are there countervailing interests, like state interests in promoting public health, and also legitimate expectations. Obviously, sole effect would favor companies, since like Eli Lilly obviously doesn't have patents anymore. And there is also one other asterisk, which is Rochelle mentioned that in many agreements, there's an exception. There's no expropriation for IP rights that are properly denied or canceled in accordance with the IP provisions. But then you have to look at those IP provisions, and it doesn't prevent a case from being filed, and who knows what commercial arbitrators are going to decide complies when they're not schooled in IP law. Now, expropriation, I think there still could be claims, but that's not the one that's most dangerous. Most investors succeed not on expropriation, but fair and equitable treatment. What does that mean? It's huge in terms of what it means. So some broad decisions say that investors are entitled to a stable legal and business environment. Well, that's basically like nothing ever will change, which seems kind of crazy. But that's what some tribunals say. Some others say that they have to have legitimate expectations and that they have to be based on specific state representations that the investor relied on. That sounds kind of more plausible, but depends on who you're asking. So I think to patent lawyers, it's obvious that a patent is not a guarantee that it's going to remain valid. Patents are invalidated all the time. There was a recent quote from Justice Kagan saying, we assume contracts are valid because they are, but here we're in a different universe with patents. You flip a coin. She's being a little flip, but patents are invalidated a lot. But Eli Lilly's claiming that by having a patent, the state is representing it's valid, it cannot be invalidated. So I think that if you presented that to commercial arbitrators, they might agree. So I think that this didn't change. Okay, the first problem I see is recognizing that there is a problem, right? I didn't just get this from an AA meeting, not that I've been to one, but I know that this is how you fix problems. You first identify that there is one. And the problem I see is that most people don't even see that there's a collision course between IP and investment claims.
So even though investment agreements existed between WTO TRIPS and the DSU says that's supposed to be the sole mean to adjudicate TRIPS, it says nothing about investment claims, which suggests to me they never thought that this would happen. Also, I wrote like a little blog on Patent Leo earlier in the year, and I was shocked at the number of responses I got from attorneys and also patent professors saying, wow, I had no idea this was happening. People who write about patent cases. So I was like, oh, okay, we got a big problem. Also, there's defenses of investment claims that none of them acknowledge that there is a conflict with IP. So I see that as a problem too. So just some comparison between the conflict and the defenses. So I see one obvious conflict is a conflict in TRIPS interpretation. Even if you don't have two different disputes in two different forums, like we don't in Eli Lilly, we just have an investment case, just that case alone could have an impact on TRIPS flexibilities. And it obviously disrupts the WTO dispute resolution as being the sole forum. So some of the defenses that come up don't address these at all. One is that, investment process is fair and independent and avoids shotgun diplomacy. Well, we never had shotgun diplomacy for IP disputes. That's just not been a problem to my knowledge. And we already have the WTO dispute resolution, which is perfectly fair and adequate. So that doesn't address it at all. There's also a claim that these agreements promote foreign direct investment. We've heard this before in the context of WTO TRIPS. Whether or not it's true is a separate issue. Even if it is true, it doesn't change the fact that all of these issues in blue are still at risk. Another claim is that sovereignty concerns are overstated. There's actually a law review article that says that there's a meme of sovereignty being a problem. And there's another article I read where sovereignty concerns are a mere myth. But these discussions either don't cite the two cases I'm talking about at all, or just say, oh, well, Australia will probably win, as if that's not a problem, because even if they win, there could still be a TRIPS conflict, all kinds of problems. And the last thing is that, well, there's procedural protections, because it's just like U.S. law, but it really isn't just like U.S. law, because things don't have to be public, there's no appeal process, there's lots of things that are different. So quickly, just talking a little about the cases. In Australia, Philip Morris has filed a suit against so-called plain packaging of tobacco, where they can't use their main logos. And also they have to have all these unsettling images. But what the companies are really fighting about is the right to use the logo that they want. It's endorsed by the World Health Organization. It's consistent with a framework convention on tobacco. So there's this little cartoon saying that our customers have a right to, get the logo and see what they want, but it should be consistent. Now, there are some serious TRIPS issues. There's two key trademark provisions. One is that trademark use should not be unjustifiably encumbered, that Philip Morris says is violated. But to me, even if the labeling regulations encumber their use, there's that key word, unjustifiable. And it seems to me public health is pretty justifiable when you have all these people saying that. Philip Morris also cites Article 15.4 saying that the nature of the goods, i.e. that it's tobacco, can't be an obstacle to registration. And they say, well, what's the point of registration if we can't use it? Even though trademark rights in TRIPS and everywhere else is about a negative right, not an affirmative right. So a lot of people think that on TRIPS, Philip Morris doesn't have a good case, but that's not all they have. First of all, even if it's a strong case to us, not everyone agrees on these TRIPS issues. There's at least one law review article that is sympathetic to the tobacco concerns, that there might be a problem. And then who knows what the investor arbitrators are going to decide. And there's also no way to reconcile different interpretations, right? So if the WTO panel says one thing and the investment case is another, there's no way to come to a conclusion. And also, even if there's no difference of opinion on TRIPS, there's also these separate claims that they could win on even without a TRIPS violation. So that's just the tobacco case. Then there's also Eli Lilly's challenge to TRIPS flexibilities, claiming that Canada's interpretation of utility violates TRIPS and also is an expropriation and breach of fair and equitable treatment. Now, It's true that this is a kind of a different law, but it only applies if the patent applicant makes it an issue. So in most cases, Canadian utility law is just like US. You just show some kind of use. But if you say your application is for a particular use, it does something specific, then you better show that in your application. That's what the law says. That's why it's called the promise doctrine. If you promise something, you better show it. Generally, companies don't do this unless they already got one patent and now they're trying for another one, which is the case with both of the patents that are at issue here. They already had a broad patent on the general compound. Now they're trying to get a patent for a specific use, whether it's ADHD or schizophrenia or whatever. Eli Lilly is making these broad claims that this promise doctrine is unique to Canadian law, which it may be, but again, that's not necessarily in violation of TRIPS. And as Rochelle mentioned, it's kind of similar to what we expect in 112, and Professor Gold has done a comprehensive survey saying that other countries have similar requirements, just calling it different things. Eli Lilly also claims that this is unfair because, well, the Canadian government says our drugs are useful, so therefore they are, even though it realizes that patent and regulatory laws are totally different. And also what you file with the regulatory agency usually comes much later and is based on different data. They also say it's discriminatory against drugs, but technically it applies to everything. And the example in their MPEP is actually about golf balls, not drugs at all. So I think that there are strong reasons why Eli Lilly's claim under TRIPS is weak, but again, who knows what the tribunal is going to decide. So here, there's not the same direct conflict as in the plain package tobacco cases because there's no WTO case. So notably, despite pharma saying clearly TRIPS is being violated, the USTR did not bring a case. So no competing possible direct conflict. But I see a huge implicit conflict in terms of a chilling effect on the TRIPS flexibilities. And in particular, the idea that revoking a patent could be expropriation. There's patents that are invalidated all the time. That's kind of how patents work. And TRIPS even explicitly talks about how you can do that. You just have to have the right procedures. There's also a problem if the tribunal has a very expansive interpretation of what's fair and equitable treatment that's violated. So Eli Lilly is making what I think is an outrageous claim that if you issue a patent, you're promising it will be valid forever, which to a patent attorney seems kind of crazy, but this is the claim they're making. And this is not a panel of patent attorneys. So at first I'm like, this is a crazy claim, but then I presented a paper just about the Eli Lilly case to a group of international law scholars, and they were like, oh yeah, Eli Lilly's rights are violated. And then I got kind of scared. I'm like, oh, So if somebody who's not in IP thinks their rights are violated because a patent was issued, even though I told them patents are invalidated all the time, I think we have big troubles ahead, depending on how this is going to come out. Another really important issue that's being raised here is Eli Lilly says that they have a legitimate expectation that the law will not change. They think it's completely crazy that they could get a patent and maybe the law changed, therefore we should never invalidate their patent. So I guess they're not watching what happens in the US after the Supreme Court changes what's patentable subject matter, and all these patents get invalidated. So apparently that's okay in the US, but not in Canada. And this is how common law works, right? You have laws, but they're not there in perpetuity. They do change. So I think that impacts not just patent cases, but other cases as well. But all of these things are at issue. Now, these are just the two existing cases. There are also other possible problems. So there's been other things that have been challenged as maybe not in compliance with TRIPS. So one of the big ones is what India is doing with its patent laws. It's so-called Section 3D that says, oh no, you don't get a patent on something that's based on an existing compound unless you show that it's got increased efficacy. So the pharmaceutical industry repeatedly says, oh, well, clearly that's not consistent with TRIPS, and yet there's no WTO dispute. But maybe there doesn't need to be one. This could be just like the Eli Lilly case, where if you are in a country that has an investment agreement with India, you just go ahead and bring your case. And in some ways, it's a lot better because unlike a WTO situation, you don't have to lobby your country. One, you just go ahead and file. And two, if you win, you get all the money. Unlike the WTO case, you don't get anything. You just get the law to change, but you don't get compensation. The other thing I see is a problem with compulsory licenses. So all kinds of policy makers suggest that some countries should use these more. But there's a lot of debate, discussion, incorrect statements about compulsory licenses. So even though we have the Doha Declaration, even before the most recent declaration saying that these are proper, you still have people all the time saying compulsory licenses are not proper and are not in compliance with TRIPS. But I do think that they could easily be challenged in the near future. So that's just for patents. I also see potential problems with regulatory laws, right? So countries that don't have data exclusivity, which is something the pharmaceutical wants, or maybe they have it now and they want to change their laws, which is on the table in some countries, that could be a problem. Also in Europe, they're trying to make their data more transparent. And the pharmaceutical industry is protesting. So that could be also another issue. So I would agree with Donald, who's not here right now. Oh, back there, who's talking about forum shopping. So to me, obviously, forum shopping is how we got to TRIPS. But I see investor-state disputes as the next arena of forum shopping. You got TRIPS, you got TRIPS Plus, and now we're moving to investor-state disputes, where you get even more. And you're being adjudicated by a very small group of arbitrators. So yeah, it's true that each side gets to choose one, but then it seems to be it's only about a dozen people who are deciding most of the disputes. And you could decide a dispute one day, and the next day you could represent a company. So it's very different than how we do litigation, even though those who defend this method say it's totally like US litigation. So what can we possibly do? So I've got some suggestions. These are not complete fixes, but some suggestions. One is that in the investment state dispute settlement system, I think that invalidated IP should not be an investment. Because what we're saying when we invalidate IP is that it never should have existed in the first place. And I think we need to have this interpretation because IP is different than regular property. With regular property, you don't need any state to decide whether it exists, and it doesn't usually cease to exist. I mean, you can have an action quiet title, but that's rare, totally different. But IP and especially patents get invalidated all the time. I also think that in the investment arena, they shouldn't adjudicate violations of TRIPS, because clearly that's what the dispute settlement understanding is supposed to be for. But if they're not going to do that, I think the arbitrator should at least include some IP public health experts. So there's at least more recognition of things, and maybe they consider the declaration. I mean, it's there, and theoretically they should look at it, but who knows? At the WTO, could we do anything? So I'm not sure, but I was thinking, what if we had something like the original Doha Declaration, where the countries agreed not to utilize investment claims for TRIPS issues? Maybe theoretically we could amend the dispute settlement understanding, but considering that it's taking forever to amend Article 31 bis, where everyone says that that's a good idea, I'm not super optimistic. But if we had some kind of declaration at least acknowledging there's a problem like we had with Doha Declaration, I think that'd go a long way, because currently many people don't even understand that there is a problem that we need to be looking at. So lots of press on investor-state disputes as being unfair, too much in corporate favor, but they don't see that this is a problem for IP. So that's a lot of stuff that I'm condensing, so hopefully it made some sense, and thanks for your time.
All right, this is it. This is the last one. We're almost done. So I'm gonna talk in the end specifically about TPP, but first I want to actually kind of sum up a little bit why we're here today and actually defend the declaration. I mean, Reto came all the way out here to get people to talk nicely about his declaration. I'm going to be the one. So I'm going to respond a little bit to both Dawn, who has run away, and a little bit to maybe Rochelle, in the concept of kind of answering what I see as the big questions around the declaration, which is the first one is like, why flexibility? Like, why is it really important? And the second one, why sovereignty? And this comes up in a couple of the critiques of why are we focusing on that? Why don't we give more guidelines on how to solve problems instead of focusing on this kind of relationship between the state and international law? And then I'd like to lay out a little bit some of the kind of interpretive norms that I think support the declaration. And then at the end, I will trace a little bit how the TPP is going in a different direction and compare it to some of the norms. So it's, in some ways, it's two different parts of the project. So first, why flexibility? Why this focus on finding, as Rochelle calls them, the loopholes within TRIPS and encouraging countries to exploit them? And on one level, you know, there was an argument in the TRIPS days that there might not be a real necessity for lots of flexibilities, that patents won't really cause huge problems. There might be some needs in the cases of emergency, et cetera, to have maybe a rare compulsory license, but there won't be a systemic problem between patents in poor countries. And the reason is because monopolists will act like good entrants in the markets, and they will lower their prices within poor countries. And maybe they need some extra parallel importation protections to do it, but for the most part, as long as you have that basic rubric within the countries, they will treat the markets independently, and they'll have lower prices in poorer countries and higher prices in richer countries, and that's okay. Overall, we'll proportionately pay relative to our income. And so my claim is that that's exactly wrong, that actually the logic of the system produces a very opposite problem. And Fred alluded to that, which is that the logic of the system will actually cause poor people in developing countries to have higher burdens than middle-class people in wealthy countries, and that that's not a flaw in the system, it's a function. It's exactly how the system can be expected to work. So, you know, how does this work? So first, you know, we witness this. So whenever I talk about this issue in my classes, et cetera, I always start with this slide. It's probably the most used slide by NGO activists around IP around the world, and it's this story, right? It's this story that in 1999 and 2000, before there was much generic competition for AIDS drugs, Fred alluded to this, were priced at the same price in all countries, rich or poor. So you want to buy a 3-drug cocktail in Uganda, GDP per capita less than $300 a year per person, right? $10,000 is the price. You want to buy that same cocktail of drugs in the United States, back then, $35,000 a year, GDP per person, $10,000. Same price, rich and poor countries. And you can go through all kinds of different drugs and all kinds of different goods. And in fact, you know, a report that I helped work on, Media Piracies in Emerging Markets report, shows that the same thing happens in copyright too. You want to buy a CD from a normal store, you know, in an airport in Uganda, it's going to be higher than the price you'd pay for the same CD in New York City. There's no cost of distribution problem. You can print a CD anywhere, as the content owners will tell you. So there's something else going on. So these are a set of charts I use in some of my classes to kind of illustrate this. And the lesson is that if you're in a monopoly market, then what sets price is the willingness and ability of consumers to pay that price. If you're in a competitive market, it's the supply side that sets the price. If a new competitor can provide that good for a lower price, and you're charging a higher price, then a competitor will enter the market and undercut you. So in a competitive market, it's the supply side of the economics equation, the cost of production, that ultimately sets the price. The market will level down to the cost, the marginal cost of producing the next item, which includes a reasonable profit to attract investment, et cetera. But in a monopoly market, it's willingness and ability to pay. You will keep raising your price until an additional raising of the price is no longer profitable because of the decrease in the number of people who purchase it. So these are demand curves. So what happens in the right side if you sell a price for 100 and no one buys it? If you decrease by 10 more people will buy it, and it goes all the way down the line, right? So in this market, the profit maximizing price is exactly in the middle. If you decrease your price further, you don't gain enough more people purchasing the item to make that profitable. If you price higher, you don't sell enough to make it the most profit, so you will exactly price in the middle. So what does that mean? That means the bottom half is the deadweight loss. Those are the people who would have purchased the good but can't at your price, and the other people all that would have paid more is your consumer surplus, right? So in the other, it's a different equation, a different slope of the demand curve. It's a steeper curve. Here at the very top, you actually do sell 10 items. But as you decrease your price by 10, only one additional person buys it. So you're not getting very much pickup in volume. So it just illustrates the rule. It totally depends on what the ability and willingness to pay is. So in that market, your profit maximizing price is much higher. So where your profit maximizing price hits depends on the slope of the demand curve in the given market. And the slope of demand curves in your market will be different depending on where you live, right? So in the United States, so if you take now I'm going to talk about medicine. So if you take a needed medicine, the assumption is people will be willing to buy it if they can, right? That's why we call something a needed medicine. If it's going to make you live longer, it's going to make you healthier, you're going to be willing to pay some percentage of your disposable income. We took, and this is from an older paper, took 5%, somewhat randomly, but there is some evidence in US policy that people tend to not spend more than 5% of their income on out-of-pocket medical expenses, but it really doesn't matter what you set it at. The point is that the demand curve in a country will be relatively the same as its distribution of income. So whatever you set it at, if you set it at 5%, then the price, this is what you'd set the price if you're only selling to the top 10% of the economy. If you were going to sell to the top 20% of income earners, your price would drop to about $3,000, right? And you do the next 10%, it drops continually, etc. And the other side shows what you would be making with each one of those price decreases. So at each price decrease, you are doubling your sales volume. But because the price is variable, you may or may not make more money, right? So on the other side, it shows when you drop the price from the top 10% to the next 10%, you make more money, you pick up more volume. And you make more money again when you decrease it to the third, the fourth, the fifth. So you end up serving in that market about half the market. Where it starts falling off is where you no longer have an incentive to decrease the price in order to pick up more volume. So that's the United States. The United States, you expect a monopoly holder to serve about half the market. And about half will be deadweight loss. So it's similar to that first graph I showed, the 50%. But what if you go to developing countries? So developing countries, the pretty much structural problem in every developing country I've been to, it's even more in middle income countries, is income inequality. So there is a segment of the population that is integrated into the global economy, that gets paid in dollars and pounds, that earns similar to what people make all over the world, but relative to other people in that country, they're super rich. And so if you take that, look at the gap between the top 10% and the next 10% in Argentina. It's so large that when you decrease the price and you're only going to double, you can decrease the price by about to 25% of the original price, but you're only going to double the volume, it's not profitable. So you see in this graph, you make the most money by only serving the top 10% of the economy. And Argentina actually isn't that bad. If you go to Brazil, it's even more stark. So the more inequality you have within the country, the more the profit maximizing incentives for the monopolist is to price only to the top tier. We could only get income by deciles. If you probably could know what the top 1% is, you'd often find that the profit maximizing behavior would be going all the way to there. So what is to pause there and just take the implications of the lesson. So the first is that the access problem in developing countries is really severe, and it's more severe than it's going to be in more wealthy countries like our own. The second is that the incentives are going to be very small. Because you're pricing to the very top 10 or maybe even a smaller segment of the economy, although you're making those sales at high prices, you're not making very many of them. And this is why we have neglected diseases, et cetera, that the markets are so small that even though you're going to charge very high prices, you're not going to make very much money out of it. You're not going to have very much incentive coming out of that given market. Which means that patents are not going to be a very good tool to incentivize innovation for those markets. So, here I would take an issue with the second part of Rochelle's paper of then saying, well, I don't really like what you're doing with the declaration, but the better thing would be to have, different length terms in different countries based on their GDP. Well, I don't think that's a very good solution because it doesn't get over this problem. So, okay, you're going to have this excessive pricing for 5 years instead of 20 years. That's better. But a better problem would be to solve the whole problem and actually de-link the innovation incentive from the price altogether. And so if we're going to think outside the box, then let's think completely outside the box. And people are doing that, talking about R&D treaties, et cetera, et cetera. Okay, so why sovereignty? This was another kind of critique of the declaration. Well, you're focusing on sovereignty, you're not focusing on guidelines or more useful information, et cetera. And my response to that is actually, we should be focusing on sovereignty. We should be focusing on sovereignty because that's where the huge shift is happening. So if you look at the long history of intellectual property law, and here, going back to the working issues that Marketa was talking about, but going back even further. I mean, you go back all the way to where I start the beginning of intellectual property law is really royal franchises. You always had a link between a duty to serve with the monopoly grant. That goes back to the 12th century. But as you watch the shift through what I call the three globalizations of intellectual property, what shifts is the relationship between international law and the state, particularly with regard to those flexibilities. And as we move into the last period, what I call the third globalization of intellectual property, there is a very dramatic shift in international law here. So in the previous stages, you start in the first liberal period in the 19th century, international law interferes, but we still have a dominant conception that states, like individuals in contract law, are sovereign within their spheres. And international law comes to regulate the space in between two states. It's horizontal in its application. You see that in the Paris Convention. Rules like national treatment, etc., are regulating primarily horizontally. But as you shift into the second globalization, what becomes dominant is really this idea that intellectual property, like other laws, is a means to an end, and we should tailor our intellectual property to our specific interests. And this is when India adopts process patents, and Argentina gets rid of patents for pharmaceuticals. Canada adopts its compulsory licensing regime, etc. The third globalization has a change in process and a change in substance. So in process, we've talked about the shift to trade. We're also shifting to more secret processes. We're shifting to a much higher use of coercion, starting with the Special 301 program. There's a regime shifting that takes place. First, we shift from unilateral Special 301 to multilateral to the World Trade Organization, then to bilateral free trade agreements, and now, and this is the capstone, plurilateral. And that's this step where there's this big question mark of whether the agenda is going to continue. So the TPP represents the second plurilateral agenda. The first one, ACTA, failed. So it was negotiated under these same processes of secrecy, the same goals of TRIPS plus enforcement and substantive rules, and the idea that they could kind of do that within a small country club of like-minded countries with a mechanism for expansion. So ultimately it would become a new global norm. So you would negotiate it secretly between a small group of countries and then globalize it ultimately through a multilateral institution. That was the goal of ACTA. It's the express goal of TPP. ACTA failed, was voted down in the European Parliament, was never subjected to ratification in the United States. It's signed, it's not ratified, it's not a dominant agreement. But, so both ACTA and TPP and TRIPS and all the FTAs and Special 301 also make a substantive shift, which is now we're not regulating horizontally really at all. It's straight up vertical regulation. We're regulating through international law the relationship between the state and the subject directly. So trade-related aspects of intellectual property rights, what's the trade-related aspects? Which parts are subject to trade? You know, Article 27 says you shall have patents. It's not about patents for foreigners, it's about patents for everyone. It's regulating regulation. So international law is now coming and regulating what our states can do. So if TPP passes, it's ratified in the United States, Congress cannot change the Digital Millennium Copyright Act to adopt Canada's system of notice and notice. We have to have notice and takedown forever because international law says so. Because we've signed an agreement which then would have to be renegotiated with 12 other countries in order to change our domestic law. That's the implication. We're regulating regulation directly. We're taking away the ability of the local population to decide through its representatives to change their own law in a direction that they choose. That's the controversial part. This is why focusing on sovereignty is so important, because that's what's changing. What's changing is sovereignty. Sure, we should have projects to give people better advice about what to do as a policy, but I think taking on sovereignty directly is exactly the right move. It's also a move that fits into a global agenda. So this stage that we're in, the third globalization of intellectual property, I call it, is defined by conflict. So the second globalization has not gone away. The globalization in the 50s and 60s and 70s that was concerned about law as a means to an end and concerned about the ability on a policy angle to tailor laws to those ends, to make laws serve the human ends in which they're intended to, that's still there. It's in the first sentence of the Declaration. As a framework regulation for innovation markets, the patent system needs to be tailored to the innovation process, which it is supposed to serve. So that it situates the Declaration within what I call the development agenda on this chart, which is opposed to the enforcement agenda, which is producing ACTA, the TPP, et cetera. So the enforcement agenda is the extension of the TRIPS process. It's extending further the regulation of international law on the vertical plane. It's doing it through processes that continue to regime shift between unilateral and plurilateral to become more and more secretive over time, right now to shove the multilateral aside. Its idea is a one-size-fits-all. We've heard that a lot today. A one-size-fits-all harmonization project. The goal of the project is for everyone to have the same substantive intellectual property law dictated by international law to the local law. It has particular norms that it's trying to achieve.
and things like enforcement and penalties, moving to deterrent penalties, moving away from kind of compensatory type systems. And against that, the development agenda, which Margot just came back from in WIPO today, is concentrating, it's being led by developing countries, India, the Africa group, the so-called GRULAC, which is the Latin American groups, in Brazil. It's focusing on WIPO, it's focusing on the multilateral agenda, it's focusing on the tools even within the WTO. It benefits from transparency. Why do we have so many leaks from the TPP? Because some of the TPP members benefit from transparency. They actually get technical assistance and they get better norms in a more open environment. That's the dominant environment in the development agenda. We see WIPO, for instance, televises its meetings on the internet, opposite of the TPP, right? They're trying to open up further. The scope, what is it focusing on? The development agenda is focusing on flexibility in the protections and mandatory limitations and exceptions. This is what the Marrakesh Treaty is about, for instance, an entire treaty going through the development agenda process that's focused on the limitations, not on the protections. Mandatory limitations and exceptions. Enforcement, focusing resources on private enforcement, damages, etc. And in each of those, and I think this is important in the interpretation of the agreements, there is both the Doha Declaration, which is a further agreement that we've mentioned, saying that TRIPS can, and more importantly, should be interpreted to promote access to medicines. It gives an interpretive norm to break these ties we've talking about in ambiguous language. And second, on each of these dimensions, there's human rights norms as well. And in talking about the different norms that we should be interpreting the agreement to, we see down here subsequent agreements and subsequent practice in the parties is named as interpretive norms that we should be looking for. So we don't need to only go to, well, the drafters could have said this. In fact, we've got tiebreakers from the Doha Declaration and from human rights norms themselves. So if you land on ambiguity, before you get to legislative history, Don, where is he? Before you get to legislative history and what pharma wanted, you're supposed to go to the declaration, the Doha Declaration and human rights norms. And that leads to the last slide with a couple minutes of where are we with the TPP. And the upshot, it's a mixed bag. You can see norms that reflect both the kind of core of the development agenda and the core of the enforcement agenda reflected in the agreement itself. So we won some, we lost some, right? Scope of protection, clear loser. There's huge debates about whether the TPP was going to require patents on new uses. The final language is different than the US originally proposed, but at least I conclude, I would love to hear others, that it essentially seems to require patents on new uses. It uses the word "the parties confirm" instead of "the parties shall." I'm not clear the legal import of that language. Data exclusivity. So, the declaration talks about data exclusivity being clearly not required by TRIPS, but it is required by the final TPP text, including a longer data exclusivity for biologic drugs, the first time that's ever been included in any trade agreement. Term extensions, not dealt with in the declaration itself, but the so-called May 10th agreement is part of this development agenda, the instruments of the development agenda, which made patent term extensions permissive for Peru and Colombia. The implication was all developing countries would get that flexibility going forward, but that flexibility was taken away within the TPP itself. But there's a couple areas where there's potential wins. So the regulatory review exception, the declaration says that you may have a regulatory review exception. The TPP actually says you shall. So we've moved to a mandatory limitation and exception within the agreement. I think that's positive. Damages, that's, I think, a clear loss. Compulsory licensing, so The declaration, we've been talking a lot about how it says differentiation is permissible within the compulsory license. I think this language is potentially interesting. It's ambiguous, but I think you can use it to kind of promote flexibility within that part. Past free trade agreements, particularly with Morocco and I believe Jordan, actually had restrictions on the use of compulsory licenses. Later FTAs did not. The TPP actually has a clarification of flexibility in that regard. And then perhaps most interestingly for the topic of today, the three-step test. There's really nothing on it. I mean, there is a three-step test built into the patent chapter. There's nothing particularly good there, but there is something good in the copyright part, which is there's a new provision, never occurred before in a free trade agreement, which comes after the three-step test. So the three-step test is there, but then it uses very fair usage language saying each party shall, and there's this soft endeavor to achieve an appropriate balance, and then it uses an open clause for purposes such as, and it names some things, but not limited to, and other similar purposes. And this to me provides very strong evidence within the agreement itself that it shouldn't, that the three-step test, the first step, the specific uses step, the limited specific uses, should not be used to challenge the flexibility of fair use, for instance. And I think it potentially gives a rubric to kind of move into the patent space, which this patent declaration is trying to do, and build a case for a more kind of holistic analysis. So I don't think we're already there, but I actually think the thinking that was in the copyright statement on the three-step test did kind of filter into this. And more importantly, it shows that at least on the copyright side, there is a renewed influence of kind of nonprofit groups, et cetera, but allied with technology companies, clearly. And I think the influence of Google and some of the other companies that have come on board and created an insider-outsider strategy that could influence both the US and through technical assistance other countries and drive positive language forward is present now in the copyright space. It's still weak but present and is starting to show influence. And the final question will be whether the TPP is met with this or it will actually be passed. And we can comment on that in questions. Cheers.
So, questions? So, Carrie.
This is just a comment for Cynthia. I thought the paper was terrific, and I'm here mostly as an amateur in the IP patent world, but when you start talking about ISDS, then you're in my area of expertise. I am one of those commercial arbitrators sometimes. And all I want to say is, and it sort of goes to, I think, some of the larger themes here as an international law teacher about legal pluralism. I mean, who is ultimately going to get control over these questions is one thing that you're all talking about. Is WTO, is it going to be national sovereign courts, and is it going to be international arbitration panels? And my comment really, Cynthia, is to say that ISDS is also a moving target. It's also changing. I wind up, unfortunately, sounding, especially in the TTP debates, like I'm defending it too much. I was part of the group. I didn't actually sign it, but I participated in some of the drafting in opposition to Liz Warren and Dean Chemerinsky and Cato's opposition to it, because I think there are people who don't know enough about that system that are criticizing it, and the secrecy and all of that is true. But as you have up there that there ought to be public health experts and all of that, there are some, and most importantly, and you guys that do WTO know this also, there have been great inroads into amici representation, and as a result of some of the grassroots stuff that some of you have been talking about, there's Don, he's not here. As a result of your last picture up there, as a result of some of the grassroots work at all levels, I think that the investor-state arbitration world is changing also, and in two ways. One is, as I said, amici and change in treaties themselves, change in the arbitral rules, And I think anyone who's going to talk about this also needs to take a look at who those arbitrators are. There's an enormous generational change, not as much total diversity, but it's not totally the grand old men of Europe anymore. And I do think, because of the kind of work that everyone here is doing, that there's been some reaction to that. So when I teach international law, I'm more interested in having students understand the legal pluralism that I think we just saw. Those charts are fabulous, Sean, really like them. That you're operating in a world of legal pluralism, and where patent and IP used to be considered, and by many still is, sort of its own silo and having its own venues. What we're here talking about is that's not true anymore. Should it be left to purely sovereign institutions? The answer is no. It is in a variety of multiple international tribunals, and I think you just need to describe them as also responding to and reacting to all the criticisms of the whole regimes plural that we've been hearing today. Otherwise, thank you to both of you. Terrific papers.
Can I briefly respond?
Yeah, absolutely.
Everything you said makes total sense to me. I just find it frustrating that even though investor-state arbitration is changing for the better, I think, the so-called, gold-plated procedural protections in the TPP don't address any of the issues I'm talking about. So they talk about forum shopping between domestic and investor-state tribunals, but not investor-state versus the WTO. So I shouldn't say like it's horrible, because I do see that there's changes, but my concern is it's not change. No one even acknowledges that there's an IP problem. To me, that's a huge issue. Some people, right? But I think it's just not enough people. Yeah.
Marketa,
Thank you for interesting presentations. I have a question that's actually somewhat related, and the question is, do we need a private cause of action in international IP disputes? For me, the move to the investor-state dispute clearly shows a desire to have private cause of action standing for a private party against a country. Again, in countries where international treaties on IP are, or at least some provisions of them, are directly applicable, have direct effect, are self-executing, certainly there parties can go to a national court, but then of course the perception might not be that this is a venue that affords sufficient impartiality. And from that perspective, some kind of arbitration panel might give better feeling or better perception of impartiality. I also assume that there's a private cause of action in cases where parties can bring a case in national court challenging IP rules that are implementation of international treaties, but might be inconsistent with other laws in the country, particularly constitutional provisions on public health protection and so forth. But I wonder whether, and I have no opinion about this, but I would be very interested in both of your opinions, whether there is time now to have private parties be able to challenge countries' IP rules at the international level, at WTO, wherever, whether that's something that would be desirable. And here, of course, I imagine all sorts of plaintiffs, not only pharmaceutical companies challenging laws that led to revocation of their patents, but maybe also users, right? And we heard earlier about users' rights or users' interests that might not be sufficiently represented. Those types of actions could actually help promote these interests.
Fred Abbott, you have a question?
No, after.
Oh, I'm sorry, you respond. Sorry.
So I think that's an interesting thought. I have to admit I've never thought about it, so these are probably poorly formulated responses that I'm going to give. I'm sure that companies would prefer another cause of action, but I actually really like the idea about users having some claim, because even though we have some ability to have amici briefs and stuff, they don't necessarily get considered, right? And it's not quite the same standing. So I think that's interesting. There's always logistical problems every time you introduce new claims. But maybe that would at least provide balance, because that's one of the issues I have with the investor-state disputes, is that it all seems one-sided, right? It's only the private companies, not even the domestic, and the public interest doesn't get any say in the matter. So I'll have to think about it some more, but thanks for raising it.
Was that for Sean also?
Yes, I think.
Yeah, so I would say no. I would hate that idea. That sounds like a terrible idea. I mean, from the perspective of, so it would aggravate a couple things. I mean, it would aggravate the vertical relationship of international law playing a stronger role over the ability to discipline local law, which I think is just the wrong direction. I mean, I think many of the problems that are being caused within the current system are that we're deciding too many issues with too strong of institutions at the international level, which is compromising sovereignty. And in the users, the question about users is I don't think it helps users at all for a couple of reasons. So first, the norms that are being enforced don't have strong users' rights. I mean, so TRIPS doesn't have strong users' rights. I pointed to a couple areas where some little tiny things got into the TPP, but it's endeavor to language. So there isn't gonna, you're not gonna win on the L&E language in the copyright, for instance. So the norms aren't strong enough. But more importantly, the higher up you go, the closer to Geneva you get, the more the plane favors the most resourced groups, which is not users. So users are dispersed and diffuse, right? They're hard to organize, and they don't have a lot of money, and they don't have institutions that collect themselves. So, these wins from the TPP, there's like 4 people that got those wins, and they're in like public citizen, a couple people there, they make $43,000 a year, and they get a bunch of plane tickets, and yeah, they accomplish something, but they don't have the ability to win lawsuits in ISDS forums or in WTO tribunals, etc. And so I think it will tilt the playing field more towards creating new, binding, stronger international law norms that will restrict the ability of countries to have limitations and exceptions as opposed to the opposite.
Just to clarify, I interpreted Marketta's question differently.
Oh, okay.
So I interpreted her question about claims as not claims under existing agreements, but new claims that would favor users. So I agree. Like right now, they would just lose. There's no point in participating based on their limited resources. But I guess I was envisioning a new era where like the agreement wouldn't just be about investors or just be about the countries. But I recognize what you're saying about adding to complexity, and these groups may not be well resourced enough.
So thank you for your presentation, Cynthia. It was very well done. My own personal view is that the Eli Lilly complaint is absurd. And anyone who knows anything about international patent law knows it's absurd. It's absurd on so many levels, I'm not sure there's a single statement in their complaint which is accurate. And the Canadian government in its counter memorial actually does a very good job of dissecting each and every one of those absurd arguments. A second line I would say, and I do have an observation and question for you, but is that I don't actually think the arbitrators are stupid. And if you look at the NAFTA dispute settlement cases, by and large, when people have tried to make absurd claims, the arbitrators have been smart enough, like in the Methanex case, to say, well, that's just absurd. And so I'm not supporting the ISDS in general. In this type of case, I would get rid of it. I think that what Eli Lilly has done is it has scared governments And the Eli Lilly complaint is one of the main reasons you're getting the pushback now on ISDS, because countries are saying, what the hell is this? You know, I mean, this is just crazy, right? And we don't want a part of it. Now that may be overstating the good graces of the governments, but I don't think it had a positive reaction for ISDS to bring this claim. Okay, so to my mind, the problem here, there's two problems with Eli Lilly. One is it forces the Canadian government to defend it and to spend its time and money, and puts pressure on the Canadian judiciary, and kind of it has this pressurizing effect which could somehow influence policy in some way or another. So the mere fact that it's being brought is bad. The second thing that I think is the real problem with the system, it's a no-lose situation for Eli Lilly. I mean, they've claimed $500 million, which is just, you know, beyond anybody's imagination of what, you know, someone could be claiming in a case like this. But if they lose, and the Canadian public is supposed to pay that, right, out of taxpayer money. We're going to pay you $500 million for your $1,000 filing fee. If they lose, they may have to pay the legal fees of the Canadian government. So that's what the Canadian government is asking for. The problem is that there's no reverse claim that can come back from Canada. So what I've been thinking about is, if I, you know, because I think the Canadian government has done an exceptionally good job in its brief, it's hard to know what else you would say, but what I would say is you need to make a claim that there's an abuse of international legal process here, and that what really needs to be done is to impose a major financial penalty on Eli Lilly that says, no, this was so bad, you should have to pay $25 million in tort damages for injury to the international legal system, because you shouldn't be able to get away with this ridiculous, asinine complaint. Now, I'm not sure we have at this stage in the game that type of action, but what I would advocate for is adding to this a counter-complaint for abuse of legal process with triple damages, so that maybe we could triple it to $75 million and at least put a cost on the company for bringing it, because there's no cost to them bringing it. It's their entertainment value and paying the lawyers. And they've got an infinite amount of money. So, you know, let's just put a cost on it. What do you think of that?
I would totally favor that. I'm sure Eli Lilly wouldn't. But you know what you're saying, I think makes a lot of sense, because to me, I agree that what they're saying is like crazy. But regardless of how the case comes out, I'm really concerned that countries are not going to use their TRIPS flexibilities just because they're worried that this is going to happen. So to me, that is a huge thing. I agree with you that if there was a serious financial penalty that was levered, then maybe that would make countries feel like they can use the TRIPS flexibility. I'm not sure that's going to happen, but we have seen in the U.S. law so when pharmaceutical companies get too much, and we've pulled back a little bit. So in terms of like, Hatch-Waxman stuff, now I can't remember which amendment it was, they added this provision where you could like basically make a counterclaim, right? Saying that this patent should be delisted, that you claim is actually being infringed when it's not. Because before, they would just list all kinds of patents that were not related because you knew the FDA wasn't going to check and see if that was actually infringed. So now there is a claim. So we've seen in the US, whether we could get that internationally, I don't know, but I really like that concept.
Oh, yeah, Michelle, Travis.
I actually had the same thought that Fred did, that Lilly's claim is so absurd. If you think about it as a patent lawyer, it's just hard to understand how it could be brought. So my question was actually for Carrie. I mean, in what sense do you see the ISDS people understanding this? Because Lilly's not a stupid company. It's costing them a lot of money too. They don't think they're wasting it. So what's yours? I'm sorry to not ask the panelists, but given your response before, I'd really like to know what you think about this. Why did they bring this book?
I would like to know too.
It's all about conversations.
Three short comments, if I can remember them all. I think it's a pretty ridiculous claim also, and I don't think that even the clever folks that sit around coming up with investment cases in order to do whatever they think they're doing, think they're gonna win. So comment number two is, I do think that the purpose of it is to encourage some of the chilling effect, right? And everybody keeps saying that these investment, and I was in Australia when the Philip Morris case got filed. Everybody keeps saying that, that all of these challenges in investment arbitration are going to chill regulations at the sovereign level. That's an empirical statement. I think the lawyers for Eli Lilly and Philip Morris are trying to do that. I think it's a very interesting empirical question about whether they've actually are accomplishing that. Every academic that criticizes investment arbitration says that, and as an international law teacher I say it too, but I don't know that it's really doing that. I mean, we're still seeing an enormous amount of health and safety regulation at the sovereign level. So for the, I think people should be studying it. But I think they're gonna lose. And the third thing I'd say to Fred is, I think your idea of abusive process is a terrific one. There's nothing, as far as I know, that would prevent Canada from making counterclaims of that kind right now. And they certainly will get attorney's fees if Eli Lilly loses. That's standard procedure under international arbitration rules like that, unless they develop their own ad hoc rules. But the arbitral fee process would allow that to happen.
Can I ask a follow-up? So one thing that I've heard is that what they want to try to, they want to try to establish that patents are property for this purpose. And, of course, that would be Canada's big win. Because the fact of the matter is, Lilly has not invested in Canada. I mean, Lilly is invested in these drugs in the United States. All the people who work on these drugs are in the United States. The only thing they've invested in Canada is the extra fee for the PCT application that represents choosing Canada. So A, do you think that's right? And B, do you think there's a chance that Canada will win on that ground? Because that's the one on which we want to see it win.
They should. I mean, that's your field more than mine. I think they should have hired you. I hope.
If that actually goes to the question that I had for Cynthia, which is, you said something about what ought to qualify as an investment. My first reaction, well, typically we give some sort of innovation investment rationale for intellectual property, right? We want you to invest in innovation, that's why we give you patents, and so we're trying to encourage innovation, we're trying to encourage investment, so it seems odd to turn around and say, but we're not going to think of that as being an investment for these purposes. Then as I think about it a little bit more, I go, well, people invest in lots of things that don't work out, right? So you may have invested in innovation and you end up with a patent that's invalid. I might have invested in developing land, and for one reason or physical reasons or for regulatory reasons, I don't get to build the building I wanted to build and so on. So I guess my question is, how do you see that playing out, given that we are encouraging investment? Is there some way to say it's not an investment without undermining our own theory of intellectual property?
I guess the way I see it is that we're already promoting IP and patents through patent laws, and then giving them this second investment claims is basically giving them more. So in my mind, it's a little bit like in the US, drug companies get patents and they get data exclusivity. So in the international realm, they get patents and investment claims. And I also agree with Rochelle that it just seems crazy to have Eli Lilly claim they made an investment because they maybe marketed the drug in Canada, but it's not like by doing anything with the patent or the invention in Canada, they were induced to research it. All drug companies are investing for a global market. And they do that regardless of the patent laws, whatever. So I guess I don't think that this is necessarily going to negatively impact our desire to have patents promote innovation if we don't count invalidated patents as investment.
with
Sort of,
yeah,
I mean,
Sean.
follow up a little bit on that. I think to some extent, I think the definition is on a different part of the agreement that's more important. So on investment and the way property has been defined, going back to these things in the 1950s, IP has really always been there. I even think the old German agreement from 1950, whatever, I think it actually listed intellectual property. You could certainly read it in. They often say intangible property, etc. But the problems are, and I don't actually have a problem with a direct expropriation of intellectual property being subject to compensation on the international level. I think that the problem is you move into indirect expropriation and the fair and equitable treatment. And those two norms have gotten incredibly mushy. And indirect expropriation and the way investment is defined does have some terms I really don't like, which includes literally, quote, expectation of profit. That's defined as an investment. So now you're indirectly expropriating an expectation of profit is a claim. Wow, I mean, you don't have that. Even Scalia is not there, right? I mean, it's so far beyond what the worst regulatory takings law is in the United States. And then fair and equitable treatment seems to just be anything. I mean, that's a really mushy category that seems to be constantly expanding. And so those are the areas in which I think you really need to tighten down. I mean, I would, and it's really interesting. I wish I had it, but the way they get IP in, there's actually a clause that says that the direct and indirect expropriation clause does not apply to compulsory licenses or the definition or revocation of any intellectual property right. Now, if you stopped at the period, you'd be fine. But then it says, comma, as long as the action is in compliance with, and TPP says TRIPS and the intellectual property chapter of this agreement. NAFTA just says the intellectual property chapter of this agreement. So Eli Lilly's saying, well, that gives me a open door to enforce the entire regulatory chapter of the IP agreement, which is technically subject to state enforcement only. That's what it says in the IP chapter, as in all the regulatory chapters. So it's this kind of back door to enforce the IP chapter through investor state when it's formally supposed to be state to state. And that's new. I mean, that's new with the tobacco case, and Eli Lilly's thing has been there since 1992, but it's only in the last couple of years that somebody's been bold enough to kind of bring that claim and say, oh no, really, that's a bootstrap for me to be in there.
So with moderator's indulgence, since I happen to have the microphone at the moment, I want to follow with, it's a slight change of question, but it's sort of along the same trajectory. So you started out saying that you admire the Declaration because it focuses on sovereignty. That's the right place to go, and the other things that seem to be the right places to go in the Declaration. And I know it's early. We haven't had the discussion about TPP that we need to have, but what does the Declaration mean for TPP, and what does TPP mean for the Declaration? I mean, some of the language is similar to what's in TRIPS, so maybe some of the Declaration interpretation is useful for the TPP, or is TPP going to need to be in Declaration 2.0, or do we need separate declarations? I mean, how useful is this anymore, given that we seem to be in a TRIPS plus and TRIPS plus environment?
Yeah. Well, I think I find these kind of declarations to be most useful during the negotiation process, I think. I mean, a lot of the clarifying where the flexibility in TRIPS is, so saying TRIPS doesn't require data exclusivity, I don't think that helps you with the TPP. TPP clearly does, so yep, you gave up a TRIPS flexibility.
So the Declaration helps the negotiators exclude the flexibility then from
the
future.
I think
we sort of pointed out where you want to want to drill down.
It points out now in relation to TPP. It points out all the areas where you lost, right? So now you can compare and say, well, you went way beyond it in all these different areas. But I think these kind of tools are helpful within the negotiation themselves. I would talk to Ray too about this with the way the copyright declaration has been used within various FTA negotiations. And the way it's used, and I think, the negotiators that claim that it wasn't specific enough, I think they're wrong. I mean, that you can take a lot of that and just cut and paste it into a trade agreement and it will do some work. You know, I mean, the language on cumulative, like you could, and we others have proposed that you actually do, you know, insert that into the actual process. And so you can use a declaration like this, you know, within that kind of a negotiation to be like, oh, here's something that you could clarify with positive language instead of taking it away. So, you know, what if you win one of these issues? What if you won the scope of protection? You got rid of new uses. You could find a clarification from the patent declaration, you know, to be, you know, and for further clarity, TRIPS does not ban, you know, I mean, so you could get that kind of language into the negotiation process. Potentially it could be helpful, as you say, where the language is exactly the same as TRIPS, and there's a lot of that in the TPP. So the scope of patentability, the first sentence is just a restatement of TRIPS. Exactly, word for word. So, you know, whatever's in the declaration on Article 27 applies as long as it wasn't taken away, for instance, in the new use statement, you know, et cetera. And in the upshot, and this is, you know, the really sharp link between Cynthia's and I's presentation, is that, you know, all that stuff potentially comes up in new forums. I mean, you have in the TPP, and I've always been really opposed to just restating TRIPS, because anything you restate is now subject to adjudication in a new forum. I'm not a fan of pluralism. You know, I'd like to have one institution that's going to take care of this stuff, and we're going to have. So now you really, you know, anytime there's an FTA that repeats Article 27, you've got a new forum to bring a test case to try to challenge some new meaning, and you can try to figure out where your best place is.
I'm reminded of some scholarship that Neil Netanel did a number of years ago with regard to the incorporation of the Berne Convention into TRIPS, right? Talking about, you know,
That's right.
Berne qua Berne and then Berne within TRIPS. So do we end up now with sort of the declaration in TRIPS and the declaration, you know, in TPP to the extent that it refers back to TRIPS?
No, totally. Yeah, there's all these new forms that take those same issues. And the investor state is key, because there's no investor state in TRIPS, but there is in TPP. So now you've got, you know, 40% of the world economy's got a private claim.
So, two small points. One is Article 31 has been interpreted that it has to be a second agreement between the parties, meaning the parties to the WTO, not the parties to the dispute. So whether the TPP is going to reflect on, in the WIPO case that Neil Natanel wrote about, the parties were almost coextensive in two agreements. Almost.
Oh, right, sure.
Yeah, and the differences are things like Taiwan is in one and not in the other.
Right.
Because of the change, you know, in China's position on Taiwan. So I don't know if the TPP is going to reflect back into the TRIPS agreement, but that just makes it worse, because then you have two different standards for all of the countries that are in the TPP. The other small comment is, I don't know that they lost that much on data exclusivity, because if you look at all of the bilateral agreements, they each define what a new chemical entity is differently. And some of the definitions of new chemical entity involve things like, you know, one tiny new drug in a large combination. The TPP, I thought, was going to take one of these really, really drastic definitions, and it doesn't seem to have, or you know, maybe you know differently.
Says
It just says
contains
it has to be there has to be a new chemical, right? So I wonder whether there's a story there that maybe you know about, or because it seems like we being the people who didn't want data exclusivity at all, got more out of it's less worse than I had, much less worse than I do. Not just that it's 8 years for bio drugs as opposed to 12, but also that it's going to cover fewer chemical entities.
So I think in general, I mean, I think you're right to some degree, and it depends on what you're comparing it to. So in general, if you compare the TPP to an FTA, TPP looks better than the FTA. But that's,
They're really different on this issue.
lots of them are different. I mean, you know, so specifically on data exclusivity, you know, the pieces that are different. Biologic, you know, so the biologic not clearly covered in some of them, but although lots of the countries are saying we would interpret it to include It says new pharmaceutical product, and then it has a definition of a new pharmaceutical product, which I think it says contains a new chemical entity, I believe. The part that they left out from TRIPS is the considerable effort. That's in some of the FTAs, but it's not in TPP. So, you know, but yeah, you're right. It's a mixed bag. It's like, it's worse than some, it's better than others. It's, you know, I mean, but it's certainly different than TRIPS. I mean, I think if you're comparing it back to kind of TRIPS or even ACTA, you know, I mean, I think ACTA is a very interesting reference point because A, it didn't go into substantive patent law at all. B, patents got taken out of almost all of it after the Access to Medicines movement against it when various things were leaked with the in-transit border seizures and all the rest of it. Some of those issues are back in TPP, almost word for word, some of them slightly changed. So if you compare TPP to ACTA, TPP is worse on the two major issues, the internet rights issue and the access to medicines issue. But FTAs, you know, FTAs are mostly worse for the most part on most issues, except Chile was a little bit more sophisticated. But, you know, if you went to like Jordan or something like that, it's horrible. You know, TPP looks great. Now, what we don't know, and none of this is ever leaked, is what the legal regime for TPP looks like. So does TPP rewrite the agreement between FTA partners? So can Chile elect to have the more flexible language in TPP versus its own free trade agreement? And it doesn't look like it, because in the end of the TPP IP chapter, there's a few issues which say Chile can keep this, Peru can keep that, which makes me think the dominant rule is you probably have to maintain your FTA if the FTA is more restrictive, but that's not clear, that's a guess.
So thank you.
Thank you.
Thanks again for very high quality presentations from both of our last speakers, our cleanup speakers. And thanks to all of you for being here, and to those who are monitoring us on the internet. Particular thanks goes out to Cassandra Flores, who is our events coordinator, who's done a great job of setting up the logistics for our speaker and for the physical facilities here. To our webcasting team, and to the other staff here at UCI who's worked really hard to make this happen. So this proceedings will be archived. If there's part of it that you missed that you would like to see later, it'll be available on the web. The papers from the conference will be published in an upcoming issue of the UCI Law Review that will be available both online and ink smeared on dead tree version. And we look forward to the final version of the papers when they come out. Thanks again for being here.
Thanks.
Very good.